First, my lord, I'm led by Mr.
The appeal is pending, my lord. Now the appeal has been, my lord, disposed of without interfering with your lordship's order. Direction has been given to your lordships to basically to hear out the matter. So, my lord, it was fixed on 20th and 21st, but I believe my learned friend has some problem on 20th and 21st.
Milord,
So, my lord, if it could be put on any other date.
the two,
That is what you want.
Milord, if your lordship takes it up, Milord, I would request, humbly request your lordship between 20 and 26th, if your lordship doesn't keep it for personal difficulty.
20 and
This is,
21st, na?
Ad interim stage, your lordship heard the matter, Milord, non-commercial matter. Milord, I am told other matters your lordship had released. If your lordship takes it up, then kindly keeps it on the 19th.
No, if it is a non-commercial matter,
Non-commercial
then it
matter.
should be released.
This is part of.
But we don't mind before your lordship. Your lordship can take it up, Milord.
No, if it is non-commercial, if
It is up to your lordship, Milord. We have no
it started
difficulty.
already over. But over by disposing of the
Huh?
ad interim.
No, but last order. কোথায় আছে বল না তুই তো জানিস সব
কি বলবো
আসছে কেন এখানে বাটার কোথায় আছে
Well, I don't know because probably at that point of time when the matter had happened.
First order. Oh, initially when your lordship
That's why when I had this determination, when I was hearing, then it was kept as a parted with regard to ad interim. The ad interim disposed of. So it has
Go before the
regular bench. It is not before this court.
Since it is marked, Milord, we don't mind coming back also. Yeah, both of us would agree.
Well, we have no.
Even though, unless it is assigned, because determination is not there. So you mentioned before the other court.
Great.
My lord, may I permitted to grant leave to file an application for your lordship's orders, correction and modification. My lord, in the master summons, affidavit on behalf of the caveatics, it was printed affidavit on behalf of the plaintiff. My lord, unless your lordship grant leave to correct the word plaintiff and put caveatics, the central filing section refused to accept this. That's why I'm praying leave.
What you want to file?
File an application for modification of your lordship's order dated 16 June 2000.
So what is the problem?
My lord, in the master summons, your lordship kindly, it has wrongly gone down, affidavit on behalf of the plaintiff. It should be affidavit on behalf of the caveatics. Only for that, the central filing section refused to accept this filing.
So what the court will do?
Only to grant leave to file.
You correct and file it.
Well, without the leave, the central filing section will accept.
Tell if not accepting, tell the court is calling them. Go. Tell the if they are not accepting, tell the center who is refusing to accept. Tell the come before the court.
Lord, may I have my lord's kind leave to men.
But to draw up and complete the order, my lord, I pray leave.
Which date?
My lord, 15th January.
5th January. Now you are woke up in July. August now. Today we are on August.
1st of August.
Give.
Lord, may I have my lord's kind leave, Lord, to mention item number 14, 19 and 21 of today's list, Lord, ordinary list. Lord, in this matter, Lord, I am being led by Mr. Banerjee, Shuddha Banerjee, Lord. He is in Jalpaiguri today. So, Lord, that is why, Lord, I am mentioning upon notice to my other side.
My lord, I am there, my lord. I had moved that modification application last Friday.
Yes.
Lordship had heard me, and thereafter, Lordship is to hear, my lord, respondent on that.
Lord, we'll be praying for not today. That is why we are.
Okay, come at 2. When the matter is called, mention.
Lord, just Lord, one more indulgence, my lord. Item number 35 of today's commercial list, my lord. My lord, in this matter, my lord, we have completed all the directions as stated by my lord in the earlier orders. Now, my lord, we wish to proceed with filing of affidavit and evidence, my lord. May I pray for upgradation of the matter, my lord? Because this matter.
What direction was passed?
My lord, to complete the discovery inspection.
Issues framed.
Issues have not been framed, my lord. We will wish to.
Which for the other side?
My lord, I am mentioning upon notice, my lord, Mrs. Suchishmita Ghosh Chatterjee is appearing for the other side.
Let issue the notice, then I will take as a to be mentioned.
I have issued the notice. Upon notice.
Nobody say.
Again, shall I mention on Monday?
और एक काम करो इसको Monday mention करो notice देने के लिए to be mention में रखो notice देने के लिए.
Extremely grateful.
Your Lordship may be permitted to mention, my Lord, I'm praying leave to file the Vakalatnama. Your Lordship, this happens, my Lord, the GS has been filed. We had filed a Vakalatnama, fresh Vakalatnama. The changed brief. The GS has been disposed of. While filing another application for Order 7 Rule 11, the registering officer has been telling me that we have to file a fresh Vakalatnama in the main suit. My Lord,
Then the main suit, you are not the advocate on record.
yes, we are the advocate.
You
on
file
record.
the Vakalatnama.
Yes, we have
Then-
filed a Vakalatnama, fresh Vakalatnama,
Then
after getting NOC. But that has been
In the
maybe
suit.
wrongly filed in the GA sections or the other
so
department.
what is the problem now?
As of now, we are filing the Order 7 Rule 11 application. Now the department is asking for filing a fresh Vakalatnama in the main suit. That is the suit registry office.
Fresh Vakalatnama in the main suit, already in the main suit, Vakalatnama is there.
Old, no, my lord.
You are
No.
not the advocate on record
No,
earlier.
earlier.
You want to file a fresh
Fresh
Vakalatnama.
Vakalatnama.
Correct. So you have obtained the no objection from the
Yes. Now, what
hospital
happens, my lord?
advocate.
What happens, my lord, when the main applications were there, there's a filing for written statement. Now there's a change of advocate. We get a NOC and we file separate GS for filing a written statement, condonation of it. Last
So
week, Lordship has
whom you are appearing, plaintiff or defendant?
and defendant.
So for the defendant and any other advocate appear earlier.
Yes.
So have you obtained NOC from that?
Yes.
So where is
And
NOC?
that has been filed before the department. Now, my lord, we have by virtue of that, we have filed 3 GS. That has been heard by your lordship last week, has been pleased to dispose of. Now, my lord, while I'm trying to file the application for Order 7 Rule 11, we have been directed to file a fresh Vakaratnama.
So
As
you are
GS
not-
has been disposed of,
Along with the J, you have not filed the competency.
that has been also
Then you
filed.
file the Vakalatnama along with it.
It is not, the department is not allowing, my lord,
For filing Vakalatnama.
fresh Vakaratnama, because it is saying, my lord, that we have to file in the main suit.
What is going on in the department?
Yesterday I was told, in a matter, hotly, that Calcutta Swimming Club, no notice of motion filed by my advocate on record. I said, why? You've taken it out, stamp punched it. They said, no, department did not accept when we went to file. I said,
What is
filing,
it?
I'm not very good, but Lord, I think it used to be stitched earlier. I don't know what is happening.
क्या है वो देखो उसको ले और कौन फाइलिंग सेक्शन को बुलाओ मेरे ऑफिस में उसका डिटेल्स लो yes
My learned junior's backs were against the wall and he has come running to me. I was otherwise not briefed in the matter, my lord.
Huh.
My lord, may I indicate? Suit, my lord, on account of claim for unpaid price of goods sold and delivered. My lord, we have said that X amount was the total invoices. They have paid X minus 1, so balance is the claim. My lord, while filing the plaint, one of the debit notes got missed. So, my lord, your lordship pointed out the error in the calculation, correctly so. So, my learned junior, my lord, we had filed an application under, my lord, Order 6, Rule 17 and Order 11, Rule 5 to disclose. Your lordship was pleased to dismiss that application on the ground that those documents were in the power, possession and custody, and some findings with regard to that signature not being there, but whatever that document is, it is there. My lord, now I cannot, my lord, file, it's a commercial suit. I cannot really, my lord, file those documents now subsequently. So, my lord, what I was humbly beseeching, it's a formal defect. So, my lord, under Order 23, Rule 1, but if your lordship permits us liberty to withdraw the suit and liberty to file afresh, because it's a formal, I cannot really proceed because the total figure I cannot tally without that document. So, my lord, it's really, my lord, it's a situation where I cannot go forward or go back.
contested
Well, they had initially appeared, but even on the last day, they did not appear, and no written statement filed. No written statement filed. But on the last day when your lordship was pleased to dismiss that application, they did not appear. It's really 24,000 is that value of that debit note. But I have that order for you.
it is there 24,763
Yes. So, man, that really is lesser than the court fees also. So, man, but the total is not tallying. So, man, I have advised them that unless it is withdrawn with liberty to file afresh, really, because it's a formal defect, we cannot improve on that.
The matters listed as to be mentioned on the prayer made by the counsel for the plaintiff. Plaintiff submit that there was some defect in the print, but this court defect in the pleadings, and the defendant and the plaintiff has filed an application for amendment, but the same was dismissed. Counsel for the plaintiff submit that the defects which is the defect which the plaintiff intend to cure could not be the print क्या बोला that cure नहीं counsel for the plaintiff submit that then that the cure could not, the print could not be cured, the defect could not be cured by way of an amendment application, as this court has dismissed the same, and as such he prayed for withdrawal of the suit with the liberty to file a fresh. Full stop. At the learned counsel for the plaintiff peruse the materials on record. The plaintiff is allowed to withdraw CS Com 800 of 2024 with the liberty to file a fresh on the same cause of action. CS Com so dismiss as withdrawn with the liberty to file a fresh.
Completely, I leave it to your lordship, and I will not make one.
I have court fee.
The court fees,
It was adjudicated one, so for court fee it cannot be.
I leave it. Great. Great.
Consequent, all application is dismissed.
But 2 is my suit, but I'm told certain defects have come from the department with regard to verification and re-verification. But we shall correct that. We shall cure the defect within a week.
There are some unpunched annexer also.
Yes. Oh, very well. I'll take
There are two
instruction.
defects: re-verification, reaffirmation, and unpunched.
Unpunched documents. We'll cure it within a week or 10 days. Lordship will grant it.
The matter is listed as to be mentioned on receipt of the report from the office of the London Master. It is found that in the report 2 defects have been indicated. Full stop. Counsel for the plaintiff prays for leave to cure the defects within 2 weeks. In view of the above, the plaintiff is given liberty to re-verify and reaffirm the verification affidavit of the plaintiff, as well as the statement of truth. And क्या बोलते ना ऊपर क्या बोल within 2 weeks from date ना बस ना जरूरत नहीं हो तो वही defects है.
Grateful.
Yes.
Grateful. Lordship, I appear on behalf of the plaintiff.
Yes.
Lordship, this is for delivery and cancellation of a sale deed that was executed
Presentation of plaint.
My lord.
Lord, I am here, my lord.
Lordship, they are on caveat. Lordship, once I move my application,
That's
I
the
shall
point,
definitely, I shall definitely serve them. Lordship, it is only come up for presentation. Lordship, because Lordship, anyways, I was humbly praying that may I move that application on Monday after serving them a copy, my lord.
My lord, may I humbly submit? My lord, there are 2 issues, my lord. Presentation tradition in our court has been not, my lord, to oppose presentation of plaint. It is ex parte. But my lord, the whole gamut now changes because presentation of plaint in a commercial matter involves not just clause 12 leave. Clause 12 leave is, my lord,
different.
There's no question of coming and opposing, because after your lordship's grant, the suit comes on record. But section 12A leave. With the latest judgment of, my lord, the Supreme Court, section 12A leave is a judicial order passed on the contemplation of, my lord, your lordship will see whether the plaintiff's contemplation is justified or not. Defendant also, my lord, has a right, my lord, to come and indicate that this is absolutely impermissible. Like, for example, in this case, 230 crore sale of a shopping mall in Calcutta
Hmm.
with their authorization 1 month ago. Constant, my lord, communication between the parties and other litigations. So, my lord, kindly permit us to, my lord, and I have got a caveat file. My lord, and I have filed a section 9 between us that served on them. 10 days after that comes the suit. My lord, on a deeper question, my lord, kindly have a look at the caveat on the original side. It's now nature of proceedings, any suit, application or injunction. My lord, clause 12, if your lordship sees the original side rules, it is only when your lordship grants leave that, my lord, your lordship, that the suit can be tried, entertained and determined by this honorable court. Once clause 12 leave, my lord, I am no one to oppose. I have no say in the matter. But once your lordship grants, my lord, clause 12 leave, in this case, I don't think there'll be clause 12 because property is within jurisdiction. Then comes the question of section A, where it's 12A. When my learned friend asks for, my lord, section 12A, I am entitled to a copy of the plaint and I'm entitled to come and say that this is not a fit case for grant of section 12A. Why, my lord, I say so is because of 4 reasons. Number 1, on the 1st of July, deed of conveyance was executed under his authorization, where, my lord, Statesman House, which is now a shopping mall, has been transferred to a third party for 230 crores. During the entire month of July, there has been constant litigation by the workers, my lord, who they've not paid workers for 20 years. Those
Lordship, may I
workers have been
kindly submit
attacking.
because now this is on merits with the greatest of respect. My
saying why I'm
senior friend would
entitled-
allow me to do that, my lord.
Let me hear. I will hear you. Let
Yes.
why what is the why you wanted to object? Let
So,
me
my
hear.
lord, this is number 1. Number 2, entire month of July, we've been, my lord, before writ courts, where workers have been attaching my bank account because I am holding his part of the sale proceeds and ready and willing to make over his sale proceeds, which, my lord, he doesn't want to take. He wants to invalidate the transaction which is entered into with his specific authorization. Now, whole month of July, you are aware of the fact because we are both appearing in writ courts before, my lord, where the workers are attaching our bank accounts, etc. Number 3, I have filed a section 9 application 12 days ago and the matter is in the list, my lord, of the honorable court, served on them 12 days ago. I didn't want to move ex parte, where our prayer, amongst other prayers, is to, my lord, put in, my lord, his part of the sale consideration because he doesn't want to, my lord, accept it. And it's been served on 18th of July 2025. Number 4, my lord, we've been told that there is further litigation on us by his other creditors, my lord, attaching our bank accounts to get his part of the sale proceeds. Long and short of it, Statesman, my lord, is a company with a defunct newspaper. They had large debts. I paid around 40-50 crores to them through myself and other concerns to pay off SBI. I, my lord, redeemed the mortgage for them, developed the property. He, my lord, on 10th of May 24, agreed that I should sell the property if he can't do it in 6 months. After I sell the property for 230 crores, my lord, he now comes back with this. And I immediately informed him upon the sale.
Yes.
So, my lord, all that I'm requesting for is a copy of the plaint. And I also want to rely on Dhanbad Fuels for indicating that this is a judicial order. Section 12A, my lord, is a judicial order.
Correct.
No one says, my lord, it's to be given ex parte. So, my lord, in a commercial matter where, my lord, a defendant has lodged a caveat, my lord, before you ask for the Section 12A order, I am entitled, my lord, to the plaint and I am entitled to be heard.
No, if the 12A is only the court and the plaintiff, the court has to see whether what are the amendments made and he has complied.
May I just take 1 minute, my lord, on Dhanbad Fuels?
Correct.
My lord, to summarize the position.
Correct.
My lord, paragraph 43, 45, what your lordship will see, my lord, is the plaintiff's contemplation
Correct.
of whether he is entitled to urgent interim reliefs.
Correct.
And your lordship will decide whether that contemplation is correct or not. Now, my lord, I am also entitled to show that there is other material either I don't have the plaint, with the plaint or otherwise, that this contemplation is absolutely false.
No,
It is for that purpose that we want to
contemplation,
be heard.
contemplation with regard to the averment made in the plaint with regard cause of action, prayer and the averments.
Averment.
Not with regard to the objection of the
No, not objection.
You are free to take an application if
Absolutely.
the court has you found that the court has wrongly granted
Yes.
this dispensation. You can file an application.
You're
for
absolutely
revocation.
correct, Milord. But when he says that this is my contemplation, we are entitled to come up and say that your lordship may be pleased to see that his perceived contemplation is totally false and incorrect. Only to that extent, not, Milord, as a defense. We'll have to take the statement, Milord. Milord, we'll have to, Milord, submit that we can only submit this based on the plaint, based on the statements in the plaint,
Correct.
treating them to be absolutely true.
Correct.
No case of contemplation is made out, and this is, Milord, suppression, if any. Only to that extent.
No, if
And I have a caveat. He has to give me
caveat
applies to suits also.
caveat applies to
If
suit
suits
also.
also, so you should have served the plaint.
Caveat applies to
Milord,
suit also unless the suit is not admitted.
Yes.
Unless the suit is not admitted,
So, Milord, the second it's numbered, before it is admission of suit, so, Milord, two things can happen. A, Milord, he can present it before the master. B, Milord, he is entitled to pray for clause 12 leave. At both stages, Milord, I am not entitled to object. Then, Milord, suit is numbered and matter comes up for grant of section 12A leave.
correct.
At that point of time, I mean, if I'm on caveat, I'm entitled to a copy of the plaint and I'm entitled to say that this is the situation. Now, Milord, I leave it to your lordship. Milord, the only thing is, Milord, please direct them to at least serve a copy of the plaint. Whatever, Milord, be your lordship's decision that whether it should be, Milord, whether we be heard immediately or whether we be heard after your lordship grants leave. Because judicial order, kindly think of it this way, your lordship will grant today. I will apply for revocation on Monday.
Correct.
Whether your lordship will permit that or whether at 12A stage your lordship will consider, I don't want to waste your lordship's time on
Because
this.
on the contemplation, what you are arguing with regard to contemplation, contemplation has been defined by our division bench in the gravel.
So,
The court has to see only with regard to the plaintiff whether he has an contemplation. It is not necessary. It is
Correct.
not necessary
It
at
may
the
be
time of
wholly
granting.
false, but I'm not entitled to say so.
No, that's why if he has taken the leave by suppressing the fact of this court has not granted, you have a authority, you have a right to file a
No, I am not
revocation.
on that.
With regard to the injunction, if you file an application, you file the caveat, naturally you have
I
to
am,
be heard.
Milord, totally, Milord, in humble agreement
CPC though?
with what your lordship says. Totally in agreement. But all that I am saying is I have a very small window. I can say that perhaps on the basis of statements, there is, Milord, no perceived contemplation which is permissible. That's the only window. Let's take the statements as correct. On the basis of this case, you have no perceived contemplation.
My lord, may I submit?
Kindly come to the 148A. Where an application is expected to be made or has been made in a suit or proceeding, instituted or about instituted in a court, any person claiming right to appear then. In a suit, any application where an application is expected to be made or has been made in a suit.
Yes.
So it is not an application. He is asking for the lead.
Well, 12A is also, Milord, only in High Court are we entitled, Milord, to, on the basis of statements in the plaint, ask for 12A.
Correct.
But everywhere else, it's an application. So that also...
No, that is Supreme Court deprecated. There, no, 12A, there is no require of the any application, separate application.
Not required. But that's grant of an order.
Grant of notary. That's why you have a right to file an application for revocation. Kindly come to 148. Whether 148 is for the suit.
148 will not.
148A.
Where an application is expected to made or has been made in a suit or proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court
Correct.
on the hearing of such application may lodge a caveat.
Correct.
So, my lord, 12A, my lord, in effect is an application.
In a suit. It is not an application. That's why, because earlier 1 or 2 cases has been done, it went up to the Supreme Court. Supreme Court has held that even though even interim application is not required to be seen by this court.
Correct.
If the prayer is made in the suit itself, the court can find that it is made out a case for 12A, urgency, taking into 3 consideration, pleadings, cause of action, and the prayers. Court can grant. If this has not been satisfied, it has to be referred to the mediation.
I'll leave it at that. But only request is, if in the event your lordship is persuaded, I don't know what is in the plane, to grant leave, please ask them to give me a copy here and now. Because 30 days he's been sitting.
Naturally, if the suit is admitted, I don't know, I have not gone through.
Yes,
If the suit is admitted,
if
the leave is granted, if the leave is granted, naturally, if caveat is there, naturally the notice is to be served to you. Without the notice, no application can be heard.
Because I don't want it on the last occasion.
No.
If your
Itself will pass.
Yes,
No
I'll-
problem.
if your
Yes.
lordship grants, I'll ask him for a copy.
If there is a word if.
Yes. That's why, if 30 days of slumber.
Well, I was surprised asking Mr. Mitra what precedent is he setting. I'll call for. Millard, I'll be very candid, Millard. I thought, Millard, it was the business of the juniors to present the plaint. But, Millard, now the proposition that is being coined, that the court doesn't have the jurisdiction to grant 12-way leave, and my learned friend doesn't have the obligation to oppose, Millard, is something unheard of. Number one, Millard. Number two is, Millard, the reason why I'm seeking for 12-way dispensation is this. Millard, the facts of the case are that Statesman House, Millard, your lordship knows this, Millard, is on the middle of Chorongi. But at one point of time, we were in certain financial contingencies, so we approached my learned friend's clients for a loan. He offered to give a loan against mortgage of my title deeds. It's a heritage structure, Millard. It is as old as 1890. Be that as it may. Now, Millard, since we were in the process of trying to generate income, so we entered into a agreement where we entered into jointly develop the property. That was a joint development. And in the joint development, Millard, it's invariable, Millard, that the promoter, Millard, who comes in, Millard, has a right to develop and he is given a power of attorney. In this case also, he's been given a power of attorney. He has his share. The only difference is, Millard, that the persons to whom the property would be let out was a decision to be taken jointly. In fact, Millard, he delayed the project, but that is not merits. Now, Millard, one day we come to know that taking advantage of the fact that the title deeds are with him and the power of attorney is with him, he sold off the entire property to a third party, who is the defendant number 3, with whom I have no privity. And thereafter, Millard, immediately files a caveat. Apprehending, Millard, obviously, everybody will apprehend. Now, Millard, when I come to know, Millard, I write to him or we call it, and Millard, it appears that the third party, we also have lodged a criminal complaint, but that's neither here nor there. So, the suit is, Millard, for delivery up and cancellation of the deed. Now, so far as mediation is concerned, today my learned friend admittedly is not the owner of the property. He sold it. The person who claims to be the owner of the property,
Conveyanced and registered.
Yes, on the basis, is a company which doesn't even have that amount of money as his authorized capital. It was floated in 2025 Four,
23 with 49,000.
49,000 share would gather. Be that as it may, that is on merits. Now, my lord, if it's a question of mediation, there's no question of me mediating with that third party A. There is no privity of contract. Number two is he will not recognize me because he will recognize my learned friend. My relief is with delivery up and cancellation, and my learned friend doesn't have title today. I'm sure, my lord, my learned friend had brought your lordship's notice that section 9 they have filed. Now, section 9 that they have filed, we have been served and we have pleaded that in the plea. In my respectful submission, nothing remains in that section 9 because of the simple reason, so far as this title is concerned, he is no more with the title.
What is the prayer in the suit?
My prayer in the suit is, my lord, for delivery up and cancellation. Page 20. আমার গাড়ি চালাতে গেলে যে ধাক্কা লেগে যাচ্ছিল
Yes.
So,
Where is the urgency?
urgency paragraphটা দেখো
So when the deed was executed?
27th, 26th of June.
7 June.
June.
Yes.
Paragraph 48. Paragraph 48. Or 48. 32 is our date of knowledge and 42 48. I need to get that third party from not creating any further encumbrance. That urgency is there.
But deed is already registered.
No, but then he can always
in possession of the property.
No, we am still in possession. It's the statesman house, Millard.
No, you are in
I'm in possession of the property in a portion of it. And the portion of it, Millard, since they were developers, they didn't, what they did is, Millard, I shall show, once they transferred the property and they were not being able to enter, they went and put on a signboard over there, this property belongs to this Hatishala. This, Millard, these are telltale signs of, Millard,
Blocked all the staircases.
and had blocked the staircases.
Where is the power of attorney?
Millard, the power of attorney, Millard, is at page 135. Volume 2, Millard. In fact, now, Millard, I was reading the other day, Millard, the Supreme Court is also now disputing this absolute power to register documents on the basis of a power. Very recently, Millard, they have come that the registrar has a duty to ensure as to whether he has that proper title to transfer. Title was with me. I have given him all intents and purposes, Millard, was to, and the development agreement is not disputed even.
Fraudulently used my letter.
Power to dispose of? Power to dispose of?
No, Millard, this power, Millard, your lordship will find is at the time of
To execute
development.
and registered from time to time agreement sale is
Kindly see the date.
19.
It's
26 March
on the
19.
same day when the development agreement was entered.
Correct.
And the power was, Millard, to, if your lordship sees the general powers, it is only for development and, Millard,
In favor of the Merlin project, defend number 1.
all the usual players except, Millard, there is clause 5. There is one power given. Page 145, paragraph 23, 24. 22, 23, 24. This is where I say, Millard, it has been misused. All class number joint.
Share the page 40.
Specific power has given Mr. Dutt.
Milord, in 2019,
23.
yes, Milord, I know. But in 2019, this power follows, Milord, from the agreement of 2019, which is at page 45. Page 55 is there. Your Lordship will find developers allocation at the bottom.
Page 45.
Yes. So where does he get the right to sell of my share without my consent? Even assuming he had the power.
Which
Milord, page 59 is my share, owner's allocation. $52.
52.5.
Yes. And, Milord, your Lordship will find that there is a clause which says that the property, when let out, would be jointly dealt. The point clause to the. Clause? Clause ni come to Milord, clause 6.
Page?
Milord, clause 6 would be page 73. কোথায়? এই, হ্যাঁ। Clause 6.2. Jointly with the owner.
Yes. And where is the deed?
Milord, this power, Milord, was given to him at page 79. এবার
Owner
impugn
shall
deed টা
grant
দেখো।
developer a nominee general power of attorney simultaneously with the execution of agreement.
Obtaining sanction, Milord, those usual things, Milord, it's not say. Now, Milord, the impugn deed, Milord, page 310, volume 3.
Yes.
First part আমাকে break হচ্ছে কি করে? Page, execution.
Where is the schedule?
Milord, the schedule, Milord, is at page 321.
321. Four bigger, 6 hotas. Total land. Total land. Total.
I beg your Lordship's pardon.
Whether your owner's location is left out or
No. Entire thing has been, except for the place where I'm running my business of newspaper on the 3rd floor, the entire thing has been disposed of.
no? Kindly come to 323.
Yes.
Second schedule above referred
Yes.
to the owner's retained
Yes,
area.
this is these 3 portions are the tenants which I have brought in. These are the 3 portions which I have brought in, and I have indicated in the plaint that this is in lieu of that clause where the developer would jointly put in this property. And this entire money has gone to my learned friend's kitty, but that's on merits. Now, so far as these are admitted tenants, there is also a tenant at the ground floor, which is HDFC Bank, which is mentioned in the development deed also. Now, kindly come to 324.
Yes.
Except that the entire property has been sold.
323.
324.
324. Nothing is there.
Milord,
Only
324 is the last page,
Signatures.
execution page. Kindly see. Vishal Jain signs as authorized signatory of Merlin, constituted attorney of statesman.
Correct.
Merlin signs on his behalf and the third party signs.
Correct.
So, Millard, and Millard, the thing is, for the purpose of execution of this title, kindly come to page 326. This is the fraud. He says that I get the right to transfer the property on the basis of these minutes of the meeting. Just a minute, just a minute.
You're not signed these meetings.
No, this kindly similar, this meeting is of 2024. And so far as this meeting is concerned, Millard, it's a document which has been signed by the parties, which does not alter the development agreement. There was a point of time, Millard, when he could not complete the project, Millard. I offered to him to buy him off. And I was in the process of looking up for purchasers who could buy my learned friend off. And he had agreed and quoted a price of this amount. Now, thereafter, Millard, it also records that in the event I am unable to pay him, which is in 2024 within 6 months, then in that event, he will get a right to deal. Now, Millard, this document cannot, in my respectful submission, Millard, alter the registered document, which is, Millard, the development agreement, number one. Number two is, Millard, this agreement, this 10th, the reason why he had to rely on the 10th meeting is because he knows under the development agreement, he doesn't have the exclusive right. So far as these minutes are concerned, it doesn't say anywhere that so far as this understanding is concerned, this will be part and parcel of the original understanding of 10th of January 2019.
So what would
But the effect is, Millard, as I have pleaded in the plaint, that this meeting which was executed between the parties never surfaced. In between, the subsequent conduct of the parties will show that they were proceeding. In fact, Millard, those portions which were let out after this meeting. And Millard, the best part is, Millard, if he wanted to enforce his mortgage, he had to put me on notice. This was done, Millard, overnight with a company, Millard, only for the purpose of blocking and if possibly depriving me of a property. So, Millard, in those circumstances, the question arises is whether I have an urgency for the purpose of an issue to be tried, number one, and an urgency to prevent any third party disposition of the property. Caveat kara koreche? Na, third party ra caveat kore koreche.
Yes.
And Millard, so far as these 3 Trent properties into which your lordship was asking me, that portion was not sold. That property was dealt with after this minutes. This minute is of 2024.
Okay.
He pulls it out, Millard. It could be a matter of evidence. But thing is, Millard, that doesn't prevent me, Millard, from praying before your lordship that there is urgency, because the third party has not filed a caveat. So, Millard, if tomorrow he disposes of the property, Millard, then I will be remediless.
Power of attorney data which would go against it.
The plaintiff has filed the present suit, praying for decree of declaration that the agreement dated 26th of March 2019 and the power of attorney dated 26th of March 20. Power of attorney dated, you correct it.
Power of attorney is
That year has not yet come.
2019.
Kindly come to the 24 page.
26/3/2019. 26/3/2019.
Millard, decree for declaration that the agreement of 26 March 2019
and
the power of attorney dated 26 March 30. I'm sorry, Millard. 3019.
2019 executed by the plaintiff in favor of the defendant number 1 in respect of the suit property, and also praying for a decree decree for declaration that the deed of conveyance dated 26th of June 2025 executed by the defendant number 1 in favor of the defendant number 2 with respect of the said property and allied prayers. Full stop. The plaintiff and allied prayers. Good property. Okay. Decree for declaration, the plaintiff decree for declaration that the deed of conveyance dated itna executed by the itna is null and void and is to be cancelled. ठीक है उस ऊपर भी हो जाएगा null and void. Full stop. The plaintiff has prayed for leave under clause under place for dispensation of the provisions of section 12A of the Commercial Code. Full stop. Counsel for the plaintiff submitted initially a development agreement entered between the plaintiff and the defendant. Number 1, and on the same day, a power of attorney is executed by the plaintiff in favor of the defendant. Plaintiff submitted that as per the development agreement, the owner's allocation share is 52.5%. 52.5%. There is further condition that if the defendant intend to let out the premises, the same shall be with the consent of both the parties. Full stop. Counsel for the plaintiff submitted. Recently, the plaintiff came to know, taking into the benefit of the power of attorney, the defendant number 1 had executed a conveyance deed in favor of with respect to assured property in favor of the defendant number 2 without the knowledge and consent of the plaintiff. Counsel for the plaintiff submitted as the deed has already been executed. A conveyance deed has also been executed, and there is every chance that the defendant number 2 will create further third-party interest over the property. They further submitted if at this stage, if the plaintiff will initiate any mediation process, till the completion of the mediation process, there is every apprehension that the defendants will create further third-party interest over this property, for which the plaintiff will suffer irreparable loss and injury. Consider the submission made by the counsel for the plaintiff. This court also perused the pleadings, prayer, and the cause of action as narrated by the plaintiff in the present suit. In paragraph 48 of the suit, the plaintiff has categorically narrated the urgency of filing of the suit without institution of pre-mediation process. Considering the above facts and circumstances, this court finds that the plaintiff has made out a case for grant of leave for dispensation of provisions of section 12 capital A of the Commercial Code. Accordingly, leave under section 12A of the Commercial Code Act is granted. Full stop. Plaintiff is admitted, subject to scrutiny by the department. Mr. Jishnu Chaudhary, Lana advocate, submits that he has filed a caveat in the present suit. In view of the above, if the plaintiff intend to move any urgent application, and file any application for grant of urgent relief, the application along with the documents may be served to the defendant number 1, to the advocate of on record of the defendant number 1 before moving the said.
That goes without saying.
Submit. Milord, I believe my learned friend wanted to move on Monday. But,
No, if you move, then I will see if it is service.
yes, no, no. But I'm not saying that. I'm saying please give us a copy so that we can prepare.
Of course. Well,
No, I'll tell you, Lordship, I just very difficult to resist, my Lord, not disturbing your Lordship by giving the actual fact, sitting quietly and listening to
I
it.
will hear.
Yes.
In
My Lord, if they give the plaint, I'll apply for revocation of leave because none of the notices have been shown to your Lordship.
very well. Let him.
okay.
So,
Yeah,
if
serve
you
the
give
main
it
court of
now,
the day.
I can possibly file it by the close of the day.
Oh,
The plaintiff is directed to serve the copy of the interim application along with the document to the advocate on record of the defendant. Number one. Defendant number one,
Yes.
in course of the
Serve
day.
both.
In course of the day.
I need your lordship's leave to not file it, I'm told. Leave কেন লাগছে ফাইল করতে?
কি?
Presentation
क्या हुआ?
Oh,
No,
unless
that is the
plaintiff,
direction.
এখন হয়ে গেছে, unless there is a number, you can't file the application.
No, earlier I find suit is not here. The injunction, the interim.
But both used to come together.
That's what they used to. Then first let the suit come. No, what that if leave is not required,
Yes.
it is going there in the department. It's coming here. The court is in dark.
But previously, we even, my lord, sometimes for urgency, we used to, my lord, present the plaintiff in court.
Yeah.
Take leave, present in
Present
court,
court, then
both
go.
numbers come and move.
Okay. Next.
Even নিয়ে নাও, নাহলে আসবে না।
Millard, leave to Millard correct this 3090.
Leave is granted to the plaintiff to correct
এই যে
the
সোমবার
year
রাস্তায়
of
লিফটটা নিয়ে নাও। কবে থাকবে? মঙ্গলবার করো না।
correct the year of power of attorney and year of power of attorney in prayer A as 26 March 2019 instead of 26 March 3019.
সোমবারটা নট শিওর।
Yes.
আচ্ছা, আমি খালি বলেছি মঙ্গলবারটা না রাখতে।
আমি করবো না বলে
ঠিক আছে, ডান।
Yes. Item.
But as I had said that I am opposing, my lord, the maintainability point itself is that, my lord, whatever my learned junior friend tried is to show on merits. But, my lord, I do not wish to waste time of my lord by showing anything on merits, because lordship is not to look into the merits, because that is, my lord, adjudication. My lord, I am on the issue that, my lord, let us assume for the sake of argument that there is fraud which has been committed. So fraud has been committed in respect of an agreement which has an arbitration clause. Now, my lord, therefore, the matter is to be referred to arbitration or not. Yesteryears, my lord, the law was little different because, my lord, there was a question if there are serious questions of fraud or, my lord, a criminal angle to it, then it could not have been referred. But the law has undergone a sea change now. The law does not say so, that, my lord, even if there are serious grounds of fraud or, my lord, a question of criminal aspect, it cannot be given to arbitration. Now it's just the opposite. The opposite is that, my lord, if it does not have a public element in it, then, my lord, it has to be referred. So, my lord, let us take only those issues which are required and show the law as it stands, my lord.
Yes.
My lord, kindly takes, my lord, the arbitration clause. Page, my lord. ওরা লাগাইনি রোদেরটা বলে দিন kindly takes the agreement, my lord.
Page.
Kindly takes page 29. 29? না ওইটা 53, ওই মাঝখানেরটা না, 53, my lord.
আমাদেরটা থেকে
Yes.
হ্যাঁ তোমার থেকেই আর কি দেখাবো, আমি এইটা তো হিয়ারিং করছি না। Okay.
15, governing law.
Kindly takes, my lord, 16. 15.1.
Yes.
The agreement shall be constituted in accordance with the laws of India and subject to the arbitration clause below.
Yes.
Shall be subject to the exclusive jurisdiction of the competent court situated in Kolkata.
Yes.
In any event, in the event of any dispute or difference between parties under this agreement, including in relation to the construction or interpretation of this agreement, or as to the rights, duties, liabilities, parties arising of this agreement, the dispute or differences shall be resolved through arbitration, which shall be administered by an institution recognized by the Government of India for dispute resolution. Such institution will appoint the arbitrator for conducting the arbitration proceedings in accordance with the rules of conduct of the under the Arbitration and Conciliation Act 1996. And Lordship will see the venue of the situs, which is the same now, is at Kolkata. So therefore, my lord, there is an arbitration clause with respect to anything under this agreement. Now let us presume what my learned friend is saying is correct.
Yes.
Now, my lord, kindly sees his pleadings. His pleadings with regard to this agreement kindly comes to page 8, paragraph 14.
Yes.
The petitioners state that the purported agreement dated 25th July 2023 is fabricated and does not bear the signatures of the petitioner.
Yes.
The said purported digital signature has not been applied by the petitioners, and therefore the said document dated such and such should not be treated to have been signed by the petitioner or entered into by the petitioner as alleged or at all. In any event, next page, my lord, even if it is being held that the said document dated such and such has been executed by the petitioner, it is stated that such execution is not by free consent, since it is by fraud, and the digital signatures of the petitioners were applied, certain particulars of which are as follows. So therefore, my lord, he is not challenging, or he is not saying that it is a dead wood. All that he is saying, my lord, that the signature has been obtained and that the signature is not by free consent. So therefore, there has to be an adjudication for this. Now, my lord, if there is an adjudication for this, and if it is not a dead wood, then, my lord, the question of not referring it to arbitration does not arise.
Yes.
So, and most importantly here, my lord, there is no criminal complaint as on date, no FIR, no GD, nothing at all.
Yes.
Now, my lord, kindly sees, before I show the law, the order or the judge, the earlier section 9 order, which has been passed, my lord, in the other matter, my lord, kindly comes to 253, 12th of November 2024. Although this is little on merits, my lord, 253, and I'm really wasting my lord's time, I should say. But, my lord, I just want to show something, my lord, which is relevant. 253, my lord. This is the earlier section 9 application filed by us, my lord, in respect of the same agreement.
Yes.
Now, my lord, this agreement contains, my lord, tranches, because these are, my lord, credit facilities given
Yes.
in respect of invoice discounting.
Yes.
This is not bill discounting, but invoice discounting, because, my lord, this particular matter, in a similar matter of this kind, against the same respondent, my lord, a matter traveled up to the NCLAT, the National Company Law Appellate Tribunal, where, my lord, these agreements are not bill discounting, has been laid down, the law has been laid down. So this is credit discounting. What happens, my lord? The agreement is to give him, my lord, credit advance on the basis of bills, my lord, which he will, invoices which he will show me that he has with third parties. So showing that, my lord, Vedanta is correct, because, my lord, he is showing me the invoices of Vedanta to get money from me to pay to Vedanta for the services and goods that he is taking from Vedanta. But this is all on merits. Now, my lord, kindly sees this order which was filed. Now, my lord, kindly comes to the operative portion. My lord, kindly comes to 259.
Yes.
259, my lord. Thus, the respondent number 1 has made out a restructuring of the loan account if not a case of payment of entire outstanding. There is a clear admission of such restructuring by the petitioner's officers. The restructuring took place admittedly after the application under section 9 had been filed. My lord, I stop here and I just give a brief background of this order is that while the section 9 was there, my lord, the earlier tranches were paid. So my section 9 with regard to earlier tranches became, my lord, it couldn't be enforced. And therefore, the subsequent due, which now I am proceeding with, my lord, is something to be enforced. The agreement remains. Only the tranches change. And that has been recorded by the Honorable Court. No appeal against this order. Had been filed. Fresh payments, disbursements were made by the lender on 23rd March 2024, 26th March 2024, 27th March, 28th March, and 10th April. The contention of Mr. Such and Such that the tenure for the repayment of loan of 2 crores has expired in July 2024 and the respondents were sitting tight over the matter without payment of a single farthing has not been established. The arguments advanced by Such and Such are questions of trial before the learned arbitrator. At the time of consideration of prima facie case, balance of convenience and inconvenience and irreparable loss and injury, a mini trial is not required to be held by court. Whether the money disbursed on the above dates after the restructuring have been repaid or not is not an issue before this court. And, my lord, the injunction was thereby refused. So, my lord, this order does not say that the arbitration clause is not there or trial will not take place. Now, my lord, apropos this, my lord, kindly sees, my lord, what is the law and why this has to be forthwith transferred for arbitration. My lord, kindly takes one judgment which, my lord, has all. My lord, this is reported in 2021 4 SCC 713.
2021?
2020 copy 2021 4 SCC 713. I'll just refer to few paragraphs, my lord, which, my lord, lays down the law. Kindly, my lord, takes paragraph 24 first.
Yes.
My lord, kindly sees প্যারাগ্রাফ 24 টা 748 এ তো দেখতে একটু এই প্যারাগ্রাফ গুলো আবার কি মাঝে মাঝে অন্য আর হ্যাঁ kindly sees, my lord, paragraph 23 onwards, because I say this judgment, my lord, considers all the earlier judgments. 23 lordship will see IS Swami judgment. Yes. And Radha Krishnan and Booz Allen being referred to. Now, my lord, kindly comes to paragraph 24, my lord, which is important, where, my lord, the court, my lord, considers IS Swami. Kindly sees, my lord, how the law changes. Justice Such and Such in a separate judgment referred to the judgment in N. Radhakrishnan and held. The above extract from the judgment in N. Radhakrishnan relies extensively on the view propounded in Abdul Qadir, which was the earlier one. The decision in Abdul Qadir arose under the Arbitration Act of 1940 and was in the context of the provisions of Section 20. In Abdul Qadir, this court emphasized that subsection 4 of Section 20 of the Arbitration Act 1940 left a wide discretion to court. This discretion, I'll show, my lord, how it has boiled down. There's no discretion left to the court now. In contrast, the scheme of 1996 Act has made a radical departure from the position under the erstwhile enactment. A marked distinction is made in Section 8, my lord will kindly mark it, where no option has been left to the judicial authority but to refer the parties to arbitration. Abdul Qadir explains the position under the 1940 Act. The present legislation on the subject embodies a conscious departure which is intended to strengthen the efficacy of arbitration. Hence, the allegations of criminal wrongdoing or of statutory violation would not detract from the jurisdiction of the arbitral tribunal to resolve a dispute arising out of a civil or contractual relationship on the basis of the jurisdiction conferred by the arbitration agreement. Then, my lord, 25. Justice Such and Such then cautioned against the use of N. Radhakrishnan's case as a precedent and distinguished it as follows. So, my lord, first he distinguishes Abdul Qadir, then he distinguishes Radhakrishnan, my lord. Kindly sees. The position that emerges both before and after the decision in N. Radhakrishnan is that successive decisions of this court have given effect to the binding precept incorporated in Section 8. Once there is an arbitration agreement between the parties, a judicial authority before whom an action is brought covering the subject matter of the arbitration agreement is under a positive obligation to refer the parties to arbitration by enforcing the terms of the contract. There is no element of discretion left, Lordship will kindly mark. There is no element of discretion left in the court or judicial authority to obviate the legislative mandate or compelling parties to seek recourse to arbitration. So nothing is left with my lord. The judgment in N. Radhakrishnan has, however, been utilized by the parties seeking a convenient ruse to avoid arbitration to raise a defense of fraud. Now, my lord, first and foremost, it is necessary to emphasize that the judgment in N. Radhakrishnan does not subscribe to the broad proposition that a mere allegation of fraud is ground enough not to compel parties to abide by their agreement to refer disputes to arbitration. More often than not, a bogey of fraud is set forth if only to plead that the dispute cannot be arbitrated upon. To allow such a plea would be a plain misreading of the judgment in N. Radhakrishnan. As I have noted earlier, that was a case where the appellant had filed an application under Section 8, faced with a suit on a dispute in partnership, had raised serious issues of criminal wrongdoing, misappropriation of funds, and malpractice on the part of the respondent. It was in this background that this court accepted the submission of the respondent that the arbitrator would not be competent to deal with matters which involved an elaborate production of evidence to establish the claims relating to fraud and criminal misappropriation. Hence, it is necessary to emphasize that as a matter of first principle, this court has not held that a mere allegation of fraud will exclude arbitrability. The burden must lie heavily on a party which avoids compliance with the obligation assumed by it to submit disputes to arbitration to establish the dispute is not arbitrable under the law of the time being in force. In each such case, where an objection on the ground of fraud and criminal wrongdoing is raised, it is for the judicial authority to carefully shift through the materials for the purpose of determining whether the defense is merely a pretext to avoid arbitration. It is only when there is a serious issue of fraud involving criminal wrongdoing that the exception to arbitrability carved out in N. Radhakrishnan may come into existence. Allegations of fraud are not alien to ordinary civil courts. Generations of judges have dealt with such allegations in the context of civil and commercial disputes. If an allegation of fraud can be adjudicated upon in the course of a trial before an ordinary civil court, there is no reason or justification to exclude such disputes from the ambit and purview of a claim in arbitration. The parties who enter into commercial dealings and agree to a resolution of disputes by an arbitral forum exercise an option and express a choice of preferred mode for the resolution of their disputes. The parties in choosing arbitration place priority upon the speed, flexibility, and expertise inherent in arbitral adjudication. Once parties agreed to refer disputes to arbitration, the court must plainly discourage and discountenance legislative strategies designed to avoid recourse to arbitration. Any other approach would seriously place in uncertainty the institutional efficacy of arbitration. Such a consequence must be eschewed. Now, my lord, kindly comes to paragraph 34. The other judgments, my lord, one after another has been dealt with. Now, my lord, kindly comes to paragraph 34. Now, my lord, kindly sees the Supreme Court has held. In a recent judgment reported in Rashid Raja, this court referred to Justice Sikri's judgment in Ayasami. The principles of law laid down in this appeal make a distinction between serious allegations of forgery, fabrication in the support of the plea of fraud as opposed to simple allegations. Two working tests laid down in paragraph 25 are: does the plea permeate the entire contract and above all the agreement of arbitration, rendering it void, or whether the allegations of fraud touch upon the internal affairs of the parties inter se, having no implication in the public domain. Now, this is what Lordship has to look into. After these judgment, it is clear that serious allegations of fraud arise only if either of the two tests laid down are satisfied and not otherwise. The first test is satisfied only when it can be said that the arbitration clause or agreement itself cannot be said to exist in clear case in which the court finds that the party against whom breach is alleged cannot be said to have entered into the agreement relating to arbitration at all. My lord, that is not the case here. He says that his signature has been obtained by fraud, or even if it is obtained, my lord, it is not in the proper manner. It was done by some other means. So that first test he fails. Second, my lord, the second test can be said to have been met in cases in which allegations are made against the state or instrumentalities of arbitrary, fraudulent or malafide conduct, thus necessitating the hearing of a case by a writ court in which questions raised which are not predominantly questions arising from the contract itself or breach thereof, but questions arising in public law domain. Neither of these tests, my lord, my learned friend's client can pass through in this matter.
Yes.
Now, my lord, apropos this, kindly comes to, my lord, paragraph 35, which I read out. My lord, kindly now comes to paragraph 36. At this stage, it is necessary to deal with the broad statement of the law in Afcons and Booz Allen. When Afcons refers to paragraph 27 Roman 4 to cases involving serious and specific allegations of fraud, fabrication of documents, which my learned friend is complained of, forgery, impersonation, coercion, etc. This must now be understood in the sense laid down in Ayaswamy and Rashid Raza. When it comes to paragraph 27 Roman 6 in Afcons and paragraph 36 Roman 1 in Booz Allen, namely cases involving prosecution of criminal offences, it is also important to remember that the same set of facts may have civil as well as criminal consequences. Thus, in KG Prem Shankar versus State, this court had no answer. They had to answer a reference made to it as follows. This court on such and such date passed the following order. Since we are of the view that the judgment of this court in VM Shah and State of Maharashtra, which has relied upon by Mr. such and such learned senior counsel appearing for the petitioner, requires reconsideration, we refer this matter to a larger bench for disposal. Let the record be placed and the Chief Justice necessary orders. Now, my lord, kindly comes to paragraph 43.
Yes.
Kindly sees, my lord, how Afcons and Booz Allen has been dealt with. In the light of the aforesaid judgment, paragraph 27 Roman 6 of Afcons and paragraph 36 Roman 1 of Booz Allen must now be read subject to the rider that the same set of facts may lead to civil and criminal proceedings, and if it is clear that a civil dispute involves question of fraud, misrepresentation, etc., which can be the subject matter of such proceeding under section 17 of the Contract Act and or the tort of deceit, the mere fact, Lordship will kindly mark it, the mere fact that criminal proceedings can or have been instituted in both cases, my lord, in respect of the same subject matter, would not lead to the conclusion that a dispute which is otherwise arbitrable ceases to be so. So even if it falls, my lord, under these categories, as my lord, he said, forgery, it has to be referred to arbitration. Now, my lord, kindly takes, my lord, paragraph 44. Section 17, my lord, of the Contract Act is quoted. Now, kindly takes, my lord, 45. Section 10 of the Contract Act states that all agreements are contracts if they are made with free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Section 14 states that consent is said to be free when it is not caused inter alia by fraud as defined in section 17. Importantly, the section goes on to say that consent is said to be so caused when it would not have been given but for the existence inter alia of such fraud. Where such fraud is proved and consent to an agreement is caused by fraud, the contract is voidable at the option of the parties whose consent was so caused. This is provided by section 19 of the Contract Act, which reads as follows. Then, my lord, for 19 is quoted. Now, kindly take section paragraph, my lord, 47. Kindly sees, my lord. the finding. Both kinds of fraud are subsumed within the expression fraud. When it comes to arbitrability of an agreement which contains an arbitration clause. Now, as to the measure of damages for fraudulent misrepresentation by which a party to a contract is induced to enter into the contract, in Smith Newcourt Securities versus Vickers, the appellant Smith purchased shares in a company known as such and such, which had been pledged to a bank as security for a loan made by the bank to the client. SMC was given the impression that it was in competition with other bidders for the shares and therefore bid a very high price for the shares. When the share price collapsed as a result of a major fraud, SMC investigated the circumstances of its purchase and discovered that the two other bidders were not there at the time of the sale. SMC then brought proceedings against the first defendant and the bank, claiming damages for fraudulent misrepresentation. Now, my lord kindly takes apropos this paragraph 44, because thereafter the case has been dealt with. Kindly sees the finding. Paragraph 54, my lord. Sorry. Point five to
54.
Yes, my lord, 54, which
Yes.
is at page 774.
Yes. It's meant to be 11:30. How much time will it take?
Another 15 minutes.
My lord,
15, 20 minutes.
we can continue this with this matter because only one reason, Lord, I got a text from Mr. Shamrat Sen, who is leading me that his unwell is not coming to court. But still, I will argue for my lord, in reply. And so, my
Who's
lord,
for the other side?
my lord, Mr. Dhruva Ghosh was there. They have concluded the submissions. We are in reply. I shall be very brief.
Okay.
And my lord,
Okay, let me
argue on.
complete. I will take. Yes.
My lord, kindly comes to paragraph 54.
Yes.
There can be no doubt whatsoever after reading the issues and some of the material findings in the foreign final award that the issues raised and answers as the subject matter of civil as opposed to criminal proceedings. The fact that a separate criminal proceeding was sought to be started and may have failed is of no consequence whatsoever. So, my lord, there was a criminal proceeding also in this matter. We therefore hold on a conspectus of these facts and following our judgments that the issues raised and answer in the foreign award would indicate that there is no such fraud as would vitiate the arbitration clause in the SSA entered into between the parties, that it is clear that this clause has to be read as an independent clause. Further, any finding that the contract itself is either null and void or voidable as a result of fraud or misrepresentation does not entail the invalidity of the arbitration clause, which is extremely wide, reading as follows. My lord, it is somewhat similar. As I read the clause before, my lord of ours, any dispute, controversy, or claim arising out in connection with this. Same language used here also, my lord.
Yes.
Now, my lord kindly takes 54.2. That the impersonation, false representation made, and diversion of funds, which are, my lord, also allegations made by my learned friends' clients, are all inter parties. My lord, this is very important. Are all inter parties having no public flavor, as explained in paragraph 34 and 35, so as to attract the fraud exception. So, my lord, today, if there is no public flavor, then, my lord, the question of inter-party disputes not being referred to arbitration, if there is a section 8, that discretion is no longer there. So, my lord, in this case also, since there is no public flavor, and, my lord, there is an inter-party dispute, I say I get, my lord, 100 rupees from him. He says, no, you will not get because the signature was fraudulently obtained. Very well. This is a subject matter of trial. And there is an arbitration clause. Now, if in these circumstances, my lord, that discretion is taken away, the matter has to refer to arbitration. And here I have a better case because, my lord, there is no criminal proceedings pending.
Yes.
Now, my lord, apropos this, my lord, we have filed a section 5 and 8 application, which my learned friend on the other day, I believe I was not there, I was informed, was said that The time that we got, we filed it. Let us take, yes, we did it. But my lord, under the statute, I'm entitled to do it. Because if there is an arbitration clause, I can always file a 5 and 8 today or tomorrow. Now, my lord, since the 5 and 8 is also on record today, I believe, today in the list. Now, my lord, the issue is that all that lordship has to see is there a arbitration clause or not. Once there is an arbitration clause, my lord, lordship has to refer it in view of this judgment. And after this, there is no other judgment which says that, my lord, this judgment which has been referred to has been in any manner set aside, or, my lord, the two tests laid down in that judgment with regard to public flavor, my lord, and with regard to, my lord, the other issue has been set aside. Now, my lord, in view of such facts, my lord, I believe, my lord, I don't need to show anything on the facts. Whether, my lord, the signature is wrongful, whether, my lord, other question my learned friend was arguing on the other day I saw is that, my lord, signatures obtained by digitally, my lord, can be challenged. But the law is little different. But this is, I should argue before the arbitrator. It says, my lord, I am not relying, but, my lord, only for academic purpose, even if your lordship wants to see, kindly takes 32 once. Okay, a copy though. Okay, though. I'm saying this is only for academic purpose, my lord. Dekha.
32 question number. Is it possible?
Now, this is, my lord, kindly sees the heading guidelines for usage of digital signatures in e-governance. This is, my lord, uploaded by the Department of Information Technology. My lord, kindly sees, my lord, question number 11 at page 32. Lordship has got it, my lord. Is it possible for someone to use your digital signature without your knowledge? It depends upon how the signer has kept his private key. If private key is not stored securely, then it can be misused without the knowledge of the owner. As per the IT Act 2000, the owner of the private key will be held responsible in the court of law for any electronic transaction undertaking using his or her PKI credentials, public private keys. So therefore, my lord, now coming and saying that my digital signature has been used, I had given it for other purpose, does not stand, my lord, because, my lord, the law is little different. Law says that it
Now
is
you
your
will get the judgments on also in the
Yes. Now, my lord, kindly apropos this, section 42 of the Information and Technology Act 2000, my lord, kindly sees, my lord, 42. Every subscriber shall exercise reasonable care to retain control of the private key corresponding to the public key listed in his digital signature certificate and take all steps to prevent its disclosure. If the private key corresponding to the public key listed in the digital signature certificate has been compromised, then the subscriber shall communicate the same without any delay to the certifying authority in such manner as may be specified by the regulations. In this case, there is no such document he has done so, but this is on merits again, my lord. Then, my lord, the explanation kindly sees, for the removal of doubt, it is hereby declared that the subscriber shall be liable till he has informed the certifying authority that the private key has been compromised. So the law is very clear on this. My lord, just coming and making an allegation we will not do, but this is again on merits, my lord. I do not wish to.
Thank you.
And, my lord, one more thing I must show, my lord, kindly takes page 5.
Of the application.
Yes, my lord, their application. I'll only rely on their application.
इनको दे दो, यहाँ रह जाएगा.
Paragraph 8, my lord, page 5.
Yes.
Of his application, page 5, paragraph 8. Kindly sees, my lord, his own assertions again.
Yes.
In or around 29 December 2023, petitioners were served with an application under section 9. The petitioners are, kindly sees, my lord, co-applicants and co-borrowers to the purported loan. So, my lord, this is what, my lord, is already part of the records, which he has not challenged. In this particular proceeding, my lord, he has not challenged the order that I am not a co-applicant or I am not a co-borrower. He has not challenged that order to the extent that it has been initiated against him, of which he is not a party to. He, my lord, from 2023 December, today we are in July 2025, he was sitting tight. He did not do anything. So therefore, my lord, now coming and kindly sees the agreement once also. The agreement which my learned friend was showing, kindly, my lord, sees page 46 once. Although these will be all adjudicated by the arbitral tribunal, my lord, kindly sees page 46. Co-applicant number 3, lordship finds the name Sunita Gupta.
Yes.
Now, my lord, apropos this, kindly sees, my lord, the cause title. Kindly sees the cause title once, my lord. Who are the applicants before my lord, or the plaintiffs?
Sunita Rekha Manu.
Rekha Gupta. So first name is Sunita Gupta. Lordship has got, my lord.
Yeah.
Now, apropos this 46, co-applicant number 4, Rekha Gupta. That's, my lord, plaintiff number 2. Then one more, Manmohan Gupta, plaintiff number 3 is applicant number 5. So, my lord, 1, 2, 3 are all, my lord, co-applicants at page 46.
Yes.
Now, kindly sees, my lord, in the same page below, he has shown Vedanta. Correct. Purpose of loan. Facility will be utilized to purchase the stock from Vedanta Limited. I am giving him money. He has shown me invoices of which, in respect of which he wants to buy stocks from Vedanta. So I am giving the financial assistance. This is the purpose of the agreement. This does not say that money is going to Vedanta or the applicant is Vedanta. Then, my lord, kindly sees he was also showing another page by showing to my lord. Another page of this document itself. Page 81, lordship kindly takes 81. Page 81, lordship also pointed out, I remember 14, details for notice communication. This is for details for the communication of notice. There also, he has been defined as a borrower. The borrower is Messrs. Bharat Electrical, Subhash Chandra Gupta, Shushila Gupta, Sunita Gupta, Rekha Gupta, Manmohan Gupta. And all of them, my lord, have their address at the same. Now, my lord, this is for the purpose of communication, but there also he has been defined as a borrower. So he is the co-applicant. Purpose is for him buying stocks of Vedanta. And, my lord, he has been defined as a borrower for communication purposes also.
Okay.
And most importantly, my lord, there is no criminal proceeding. Even if there wasn't a problem. My lord, even if
Interstate dispute.
there is, yes,
Interstate.
inter-party dispute which has to be
As per
referred to
your
arbitration.
yes.
My lord, those are my submissions. My lord. Grateful.
I'll be very brief, my lord, in my reply. Firstly, the judgment which my learned senior friend had cited does not at all apply in our case. The reason being, these judgments and all the judgments quoted apply only between parties to an agreement.
Correct.
So if my lord sees that I am not a party to the agreement, none of these judgments apply. So my case is that your lordship would see from the agreement, I am not a borrower, I am not a party to the agreement. And I cannot be referred to arbitration. My signature appears as my digital signatures rather appear in the agreement, but not as a borrower. But on this point, may I place one judgment?
No, the agreement.
Yes.
Entered between whom?
Yes. Kindly takes a look at page
46.
Page 46.
Correct. Page 46.
So
you are
applicant may be somebody, but kindly see who is a borrower. I am not a co-borrower. No, I am not a co-borrower. I have applied. I may have at the highest. I may have applied for the loan, but it's not a co-borrower. It's not a joint borrowers. That your lordship would see from page 46. Borrower is one, applicants are others. Correct. But also the final agreement executed, which I come to learn from the section 9. Kindly sees the definition at page 75, the definition of borrower. my lord, 6 lines from top. My lord, between Ugro Capital, which is the lender, and my lord, one part, and two, the person / entity. Has your lordship got it, my lord? My lord, page 75, 5 lines from top, 5-6 lines from top. And the person / entity whose details are listed in schedule 2 here under.
The person's entity details are scheduled to.
Yes. Now kindly sees, I shall take your lordship to schedule 2, but kindly see schedule 1 also, page 80. Kindly sees the heading on the letterhead of the borrower. Kindly sees also
Which page?
page 80, 80. This has to be given on the letterhead of the borrower and also sees the name of the borrower. Only one. I am not a borrower, co-borrower, nothing.
Okay.
This is one. Then kindly see schedule 2, which I had placed on the last day also. Page 81, the next page. Name of the borrower, your lordship will find only one. Nobody else.
Correct.
Now, serial number 14. Your lordship would find the name of the borrower is there. Attention is also there. That these are the persons to whom communications would be. Some individual of a company. So that does not mean that I am a party to this agreement. So at the highest it can be taken that somebody has signed the agreement. Now whether he can be referred to arbitration if he is not a party to the agreement. Exactly on this point, my lord, the Honorable High Court at Delhi, my lord, had my lord, partly allowed a Section 11 application by referring only the company to arbitration and the directors were not referred to arbitration. May I place this? Now kindly sees the first paragraph that there is a Section 11 application where, my lord, having arisen between the parties to the agreements dated such and such. Now kindly sees paragraph 2. The agreement is between, it's a builder-buyer agreement. The agreement is between defendant number 1 and the respondent numbers 2 and 3, my lord, for 5 lines thereafter. 2 and 3 are the directors and the authorized representatives of the respondent number 1, and thereby in this capacity, respondent number 2 signed the builder-buyer agreements on behalf of the respondent number 1. Kindly turns over, my lord, to paragraph, my lord, 12. We are not even directors. Paragraph 12, my lord.
Yes.
Well, paragraph 11, the contention of the petitioners there was non-signatories are also bound by arbitration. Non-signatories, I'm sorry.
Yes.
Non-signatories are also bound by the arbitration agreement. Now, kindly see paragraph 12. The learned counsel submits that the respondent number 2 is a signatory on all the 12 agreements executed between the parties, and the petitioner's statement of account maintained with the respondents also bear the signature of respondent number 2. But I take this case also, that very well. The digital signature appears. Whether it's fraudulent or not, that's a separate issue. The digital signature appears. It is further submitted that since the respondents have filed combined reply rather than individual reply, it goes to show that respondent numbers 2 and 3 cannot be separate from respondent number 1. This was the submission. Then kindly see the submission of the respondent. Your lordship would kindly have a look at paragraph 17 onwards. The next page. In the present case, has your lordship got it?
Yes.
Paragraph 70. In the present case, the main challenge raised by the respondent is that the respondent numbers 2 and 3 are not parties to the arbitration agreements, and thus the matter cannot be referred to arbitration. It is pertinent to mention that existence of arbitration agreement, arbitrable dispute and territorial jurisdiction of this court have not been disputed. Before the court proceeds to examine the merits of contentions raised by the parties, an examination into its scope of power under Section 11 is required to be undertaken. Then the court examines the power under Section 11. I am not troubling in lordship with these paragraphs. Now kindly takes a look at paragraph 24. This really stems from the principle of Section 230 of the Contract Act, that an agent of a disclosed principle cannot be sued. Section 24 of the, paragraph 24 quotes Section 230 of the Contract Act.
Yes.
Now, my lord, kindly turns to my lord, paragraph 26. In light of the relationship of principal agent existing between the respondent number 1 and the respondent numbers 2 and 3 respectively, as under section 182 and section 230 and the jurisprudence stemming from the same, it is abundantly clear that in absence of the conditions under proviso being fulfilled, the agent cannot be held liable for or be bound by the contracts entered into on behalf of the principal. Hence, the respondent numbers 2 and 3 cannot be made parties to the arbitration. The dispute arising out of buyer-builder agreement dated such and such between the petition and the respondent number 2 is referred to arbitration without the respondent numbers 2 and 3 being made party to it. So, there also, the agreement was signed by respondent numbers 2 and 3. But that does not make them parties to the arbitration agreement, because under section 7, an arbitration agreement defines that a party, and parties is defined also, that means a party to the arbitration agreement. So your lordship has seen, my lord, from the agreement that, my lord, here, my lord, none of the, my lord, plaintiffs are really parties to this agreement. So, my lord, these judgments, my lord, really do not apply. My lord, also, the purpose kindly sees serial number 3, details of the principal borrower at page 81. This is extremely important, my lord, because, my lord, serial numbers 3 and 10, Vedanta Limited. Serial number 10, the facility will be utilized to purchase stock from Vedanta. But their section 8 application, kindly takes a look at, does not talk about any bills or anything to do with Vedanta. It's only Gupta Power Technologies and that some other company, Gladiolus or something. So any which ways, whichever way your lordship looks at it, I cannot be hauled up.
So how you can enter into this agreement?
But I'm sorry, my lord.
How you are involved in the agreement?
But I am not a borrower in this agreement.
Yeah, right.
My signature has been taken, but I am not a borrower, because your lordship would see my name does not feature as a borrower. And also coupled with the fact that the entire money has been paid. I had shown that page, my lord, where disbursed directly to the account of the defendant number 2, defendant number 3.
So what
money paid off.
What for you file the suit?
That to show this outstanding, showing this outstanding.
How the outstanding arose?
For something else.
So why you are harping upon this agreement if the something
I'm
else
sorry.
and you, why you are harping upon this agreement if it is something else you are not connected with this agreement and not connected
They
with
are
the,
saying because it's this agreement. Even their section 8 is also this agreement.
What is your claim?
My claim is that this agreement, I have no privity. And also that the signatures were obtained by fraud. I have nothing to do with this agreement.
Correct. You are telling that the signature which is appearing, that is fraud.
Yes.
Correct.
And also that I have no privity.
Where the signature appears?
In this agreement, but not as a borrower. Your lordship would see, even if I have signed in some other capacity. But I am not.
For what capacity you signed?
But I do not. I am not a director. I am a minuscule shareholder. I've pleaded that. I am a minuscule.
That's why. How you are involved in this agreement? That's why.
I am not involved in this. That is my exact case. That is why I prayed for a declaration and a delivery pen cancellation.
Where is the plaint?
Yes. But may I hand up a copy?
Yeah.
But may I hand up a copy of the plaint?
Yeah, just a minute.
267.
না আমি এখান থেকে
267 এ আছে। So it is there at page 267.
Just a minute.
Of this agreement and to civil, that is
Supplementary लगा 2 बजे specially fixed matter, specially assigned and specially fixed. Yes.
But as I said, that when I had to come to the court for the principal reason that they are reporting to CIBIL and my CIBIL score is getting affected.
Where is your plaint?
Yes, it's annexed
Which
at
page?
page 267, Your Lordship.
267.
267, third volume. Second volume, I'm sorry, second volume.
Clear.
Twenty-fifth of July 2023.
that is the master facility agreement.
Yes. That is the agreement.
That is the page 63. Page 88.
Yes, yes.
46.
Yes. So I'm not claiming under the agreement that it should be referred to. I am saying that the agreement is void.
Okay.
That is A. B is, Your Lordship would kindly see the pleading at paragraph 12 at page 273, where I've said I have no privity of contract. Page 273, last 4 lines, Your Lordship, of paragraph 12. This is without prejudice to the fact that the plaintiffs have no privity with the purported transaction of loan between the defendant number 1 and 3 and are not bound by the purported agreement at such and such.
Yes.
And Mulad, it is in light of that that I've claimed in page 279 for declaration and Mulad, delivery pen cancellation. And Mulad, my prayer E in the plaint, or rather claim E in the plaint, is injunction restraining the defendant number 1 from Mulad, reporting to any other agency or Mulad, like CIBIL and all. So Mulad, Your Lordship would see that Mulad, it's not that I am claiming anything to under the agreement that I should be referred to arbitration. I am saying that the agreement per se is void.
Okay.
That is A. B is, even if Your Lordship does not take that submission to be correct, that still a section, still it can be adjudicated in arbitration, even if that is. So I say it cannot. But even if Your Lordship takes that, Your Lordship would see that the parties can be referred to arbitration. I am not a party.
So that's why I'm telling what capacity, if you are telling that there is a for signature, digitally signature has been used forged fraudulently, correctly. So what capacity you have been taken as a party to the agreement by taking your signature
as a minuscule shareholder? All the shareholders have been given. I have pleaded that I am a minuscule shareholder. I am not a director. I am nobody.
Okay.
I did not get any money to my bank account. Nothing did I get. Yet I am being hauled up. Even the money has been paid off. Still I am being hauled up. They have issued an email saying everything is squared off for some other loan of the defendant number 3 company, which they can go against defendant number 3. I do not have any objection. They go against that defendant number 3, claim whatever is outstanding. But I am an individual staying elsewhere, not even in the same state as the company. Just because of the fact that I am a shareholder, they are hauling me up on the strength of these signatures.
RBI guidelines have been
digital signatures. And I have shown that RBI guidelines are squarely applicable. Where it's a non-face-to-face.
That you are
I have already shown. So my only submission to sum up is that since I am not a party to this agreement, I cannot be referred to arbitration.
Purpose of the law.
And the purpose of the loan also. Because their Section 8 pleadings, Your Lordship would see, they have given the invoices which are outstanding. That is not Vedanta. So any which ways, I am not liable under the same.
Para 13 of their application just show.
Okay.
And only pray, if Your Lordship is with me, that an order they should not report it to the CIBIL, because my CIBIL score is getting affected only for this purpose. Because my injunction prayer is restricted to that CIBIL. Whether I succeed in the suit, that's the later stage. But that is
Thank you.
My lord,
Yes, Mr.
I didn't want to trouble my lord, but kindly takes few pages of their application. Kindly, my lord, kindly comes to page 200. So I thought that you would agree to a reference, my lord.
Why?
My lord, the affidavit starts at 193. This is an affidavit in opposition filed by the respondent number 3 or Bharat, my lord, which was 1 therein. Now, my lord, kindly comes to para 11, page 200. The collusion is between them is clear. This affidavit,
Shareholders.
well, I did not disturb him.
Answer.
This affidavit is filed without prejudice to the rights and contentions of respondent numbers 226 and 226 were my learned friend's client. Now, my lord, let me read it. With regard to merits of the said application, in the event this honorable court is pleased to find that the said application is required to be heard on merits, the answering respondent craves leave to file affidavit in opposition and to contest the said application on merit. So therefore, one did not take any responsibility. Now, my lord, kindly comes to 251. If he, sorry, 250. If he so, as in Bengali they say, my lord, dhoa tulsi pata, then kindly why didn't he abide by this order of Justice Shobhoshachi Bhattacharya of 10 July 2024? Matter would have ended. Kindly comes to page 250. The matter is appearing in the list today for settlement. Learned counsel for the applicant submits that a proposal for settlement was given, which is denied by learned counsel for the respondents. Be that as it may, a question has cropped up as to whether the respondents, Lordship will see, he was one of the respondents. Respondents paid certain amounts to applicant. In order to establish such payments, learned counsel for the respondents seeks a week's time to file an affidavit enclosing relevant documents and incorporating necessary pleadings regarding such payments. Leave is granted to file such affidavit. My lord, will see at the first page as 250, 226 is been represented. Lordship will find the names. No affidavit was filed by them showing that payments have been made. Now, my lord, because he is a respondent to the section 9 application, so that is why he will have to. Now, my lord, kindly comes to page 248. He is so innocent, so I wrote a letter to him. Why aren't you complying the court's order? 248, my lord, kindly sees. This reference mail is dated such and such. Please note that through the said mail, we have received an advance copy of an affidavit of such and such. Please note that para 7 of the said affidavit, it appears that some purported payment has been made on different dates. We request your client through you kindly send us the bank statement for the said period showing that the said purported payment had been made to our client. No reply has come from anybody. Now, my lord, he says that payments, invoices are of Vedanta, nor of X, not of Y. Or, my lord, it is invoices of X and Y, not of Vedanta. No, this is something on trial. This is Lordship will not decide. At this position, my lord, it is for the arbitrator to decide. He has to show why he will not go for arbitration. Now, my lord, before that, just take once, my lord, section 7 and this judgment also which he has relied upon. I'm so happy he relied on this judgment. Kindly takes, my lord, section 7 once of the Arbitration Act. I think the provision itself is the answer. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. What is the defined legal relationship? That is a co-applicant. He is a co-applicant. There is no dispute, my lord. Now kindly sees an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Arbitration agreement shall be in writing. Arbitration agreement is in writing if it is contained in a document signed by the parties. He is a co-applicant who has signed. Now, my lord, whether a co-applicant has an obligation or liability or not, whether he's entitled to pay, is a question which is decided by the arbitrator.
Okay.
Now, my lord kindly sees, he is saying that his name has been referred to civil. Kindly sees is agreed to it. Kindly comes to page 52 of the agreement. Kindly comes to page 52.
Yes.
Kindly at the bottom, lordship will see 11, consent to disclosures, terms of the last, my lord, clause at page 52.
Yes.
Consent to disclosure, lordship has got, my lord. 11. Now, my lord, kindly comes to 11.2. Undertakes that the, now, my lord, B, a credit information agency and any other agency so authorized may furnish for consideration the proposed information and the date of products thereof prepared by them to banks, financial institutions, and other credit grantors or registered users as may be specified by the Reserve Bank of India in this behalf. The borrower hereby gives specific consent to the lender for disclosing, submitting the financial information as defined in section 313 of the Insolvency and Bankruptcy Act. And my lord kindly sees just below that, kindly sees his signature, Sunita Gupta. Lordship has found, my lord, digital signature. Then, my lord, lordship will find, my lord, the other signatures of the other Rekha Gupta. Then, my lord, Manmohan Gupta. All three of them have signed it. Now, my lord, whether this also under the agreement is applicable to him or not is again a question of trial. Lordship cannot, my lord, outrightly today in this situation, my lord, say that, my lord, this cannot be done.
Yes.
Now, my lord, kindly sees apropos this, the judgment is referred to. My lord, kindly takes, my lord, paragraph 2 of this judgment. First, my lord, paragraph 2. A bare perusal of the material on record reflects the respondent number 1 being engaged in the business of development and construction of real estate, entered the two builder-buyer agreements dated such and such with petitioner of such and such. Then, my lord, kindly mark, the respondent number 2 and 3 are the directors and authorized representative of the respondent number 1 thereby. My lord, a bare perusal of our agreement shows, my lord, what he is. He's not able to answer. He's saying, I'm a co-applicant. Now, what are the obligations of a co-applicant has to be looked into by on trial. Here, a bare perusal shows, we all know, my lord, if it is a company, my lord, directors are never, my lord, summoned. 2 and 3 are just directors. Now, my lord, kindly sees, this is exactly what is, my lord, there. Kindly sees paragraph 11. I thought he'll read it. Kindly sees paragraph 11. Why this theory has come. To buttress the contention that respondent number 2 and 3 are not necessary parties to the suit, the court's attention is brought to the fact that they are directors of the respondent number 1. And then the Supreme Court judgment dated such and such in Cox and Kings upheld the group company's doctrine and its application to bind signatories to an arbitration agreement. It is further submitted that the constitutional bench in this matter stated at the referral stage at section 11, high courts must let the arbitral tribunal decide whether non-signatories are bound by the arbitration agreement or not. It is submitted that it was, however, observed that under section 2.1 read with section 7 of the Act, parties include both signatories and non-signatories. Moreover, it was held that there exists a difference between signatories and third parties, as non-signatories are those who express consent through means other than signatures. So today, my lord, the Arbitration Act has expanded so much that the court even says that if somebody is beneficial by a series of agreement, even if he is not a signatory, the conduct has to be looked into and he can be made a party to the arbitration proceeding. And here is a party who is a signatory to the arbitration proceeding. He is saying it cannot be referred to. Now, apropos this, my lord, kindly sees, my lord, what the court has held, my lord, is that kindly comes to paragraph 23 now. It is amply evident from the record that the respondent number 1 is the principal and respondent number 2 and 3 being directors are only agents of the former. In order to make latter parties of the arbitration, petitioner has relied upon the judgment of Cox and Kings, read with includes non-signatories. So therefore, my lord, this is a case where the party also agreed that although he has signed as a director to the agreement, my lord, still he is a necessary party.
Okay.
This is not a case where, my lord, a signatory who is not, my lord, director, a co-applicant, my lord, cannot be referred to arbitration. That is how, my lord, this judgment is completely distinguishable.
Thank you.
Kindly, my lord, lordship, once we can file a short note, otherwise lordship passes an order.
Just one sentence each.
Again.
Only thing that's consent to civil, your lordship will find it's only the borrower who's given.
Very well, that the arbitrator will decide. Decide. And my lord, one only, these prayers which he has, declaration prayers, he can have it before the arbitrator also. Today it is allowed.
Hearing concluded. Parties are directed to file their notes of argument within a week. This is the matter on 8th August has to be mentioned for filing written notes of argument.
I'm grateful, man. Deeply obliged.
Okay. कौन वाला? तो आर्ग्यू करेगा, आर्ग्यू करेगा. 12:32, 11:30 का.
Well, item number 7.
No. It argues. 11:30 to that.
The matter, we have completed our reply, and now they are to give reply to our reply.
Yes.
We have cited, I think, 2-3 judgments, so they can only distinguish those.
And what about 12:30 क्या? वो कौन है? Who is in 12:30 matter?
Lordship, proceed with the fixed matter. Item number 7 can be.
Please maintain the decorum.
And 12:30. The 12:30 matter, matter.
Who is the other side?
Mr. Singh is there, he is there. Mr. Anuj Singh.
Okay. So, Mr. You will continue, or
in the 11:30 fixed matter is ours.
11:30 fixed matter. The train is not here.
Yes. So take it kindly. Keep.
So I am adjourning the matter.
Adjourning. That will kindly fix.
We have consumed so much of time in the previous matter.
11:30. Yeah. Item number 4. Due to paucity of time, though the matter is especially fixed today at 11:30, but due to paucity of time, matter could not be taken up for hearing. Accordingly, cases adjourned. Let the matter appear on. Give the date. 20 August at 12:30. 20 August 12:30. 20 August at 12:30.
Grateful first. Yeah.
Next. Grateful. Call the 12:30 matter.
This is I appear for the defendant respondent in this suit. GA5 is my application. Again, seeking striking off my name as defendant number 2 because I only happen to be a director of the company. That's the only point.
Yes.
I can move my application. Similar application appeared yesterday before.
Yes.
May I place?
I'll give
DA5.
praying for an
DA5.
in the other matter also, Lordship had directed for affidavits. That in this a similar application was filed. Well, I'm praying for affidavits. We can come back after that.
Well, only difficulty, the other application is for judgment upon admission. This has to be decided before. Otherwise, that has to be adjourned.
Mention I will take both together.
So this appearing today. So let all be adjourned and fixed.
When is the next one? Other matter is fixed.
Today itself, it's appearing.
Which matter?
GA3.
GA3.
GA3 is there, and GA2 is also there.
This is what is the GA5?
GA5 is my application.
Your application, and GA2 is GA2 is.
GA2 is GA2 is for judgment and decree for a sum of rupees. Yes, judgment on decree upon admission.
And 3?
3 is their application praying for injunction. from dealing and encumbering my properties.
Okay, I am passing a direction. So all and other two applications, the pleadings have been completed.
Yes, Milord.
J1 and J3, 2 and J3.
Milord, at least
No,
in
Milord,
the-
kindly give direction, Milord. We'll complete the pleadings.
All.
Yes, all three applications. All three applications, Milord.
J2 is plaintiff.
GA2 and GA3 is plaintiffs,
Plaintiff
and
has
GA5
submitted
is mine.
application being GA-Com 2 of 2025, praying for judgment upon admission, and GA-Com 3 of 2025, praying for interim order. Defendant number 2. Defendant number 2 has filed an application being GA-Com 5 of 2025, praying for
striking of the name from
praying for striking of the name of the defendant number 2 from the suit. Police. The parties are directed to complete their affidavit in opposition connected with all applications. No, parties are directed to file their respective affidavit in oppositions within a period of 2 weeks.
My lord, I am appearing in GA number 2 for the plaintiff, my lord. I'm sorry, my lord. I was addressing before NCLT, my lord. I'm very sorry, my lord. My lord, I could not be on time, my lord. My lord, if your lordship says I can proceed with the matter, my lord. I'm ready with the.
I want to
Yeah, IAGA 2, my lord.
I want to hear all the application. Let the affidavit be completed. All application will come
But
after.
affidavits, if I am not wrong, are already completed, my lord.
GA5, Melon Friend is paying for time.
And GA5, GA2 and GA3 is your application. One is judgment upon admission, another is the interim order.
Yes,
and
my lord.
I filed by the defendant number for deletion of his name. So
yes,
J1 and J2 देखो J1 J2 में
Mr. Sahu, are we intending to use any affidavit?
Yes,
In GF?
Yes, you want to file affidavit.
That is what we have prayed for.
Then, my lord.
None of the application affidavits are there. क्या बोलता? Parties are
May those be fixed for a composite hearing, my lord.
Yes,
on the day
parties are
fixed.
directed to file their affidavit in opposition within 2 weeks. Reply if any there to be filed within a week thereafter. Full stop. List all applications for hearing on. Give the date. अच्छा 3 वीक होगा ना
सर्विस होने को लगेगा
1 वीक 2 वीक 3 22 तारीख के बाद 28 29 सितंबर 1
Right, my lord.
24th or 25, my lord.
4 September 4
4th
September
September. May a date be fixed, time be fixed, my lord.
12:30
12:30, we are obliged, my lord.
The difficult. There has been a change of advocate on record, so they have served it on the GA5 also. They
Write
have
a letter.
served it.
Will
Have
give
typed
the
up the letter will they vacate.
That was a long back thing. Anyways.
Right.
But may them be clubbed and come as a composite hearing, my lord.
That's why I fix all composite hearing.
We are grateful, my lord.
Yes.
Item number 7, my lord.
Yes.
In this matter, your lordship directed us for amendment, my lord. We have served the amendment application, my lord. And my lord, my learned friend is appearing for the
last two
defendant
cases
company.
that matter relating to service upon my client, my lord, service of summons. My lord had recalled my lord's order and directed the plaintiff to take out an application for amendment of the cause title. My client's registered address was
You are
not
for the
recorded.
defendant.
I am for the defendant. My lord, we've received it. There's an affidavit of service possibly filed. My client has received it. And my lord, we're instructed we don't stand in the way, my lord. This was the order passed by my lord. It's only for amendment of the cause title.
Only cause title, my lord.
To record my Mumbai address.
GA5.
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 Yes.
So what is the address now?
And only the Mumbai address has been, my lord, just inserted.
It's a
Where you mention?
Yes.
Where is the proposed amendment?
Yes. On page 3, my lord, of the GF4 or 5.
My lord, page 25 is the proposed amendment.
So now it is a CLE private limited. That is second one.
Yes. 25.
Sole defendant. The plaintiff has filed the present application being GA Form 5 of 2025, praying for deletion of the name and address of the defendant.
The name was there, my lord, only the address.
No,
only the
CLE private.
CLE, my lord,
private notice. Only
then you have cut all these things in the first. Now, deletion, okay, praying
Let
for
me look at
deletion of the address of the defendant number one, defendant, which was mentioned earlier in the cost letter, and to bring on record the new address of the defendant company as proposed in Annexure B, page 25 of the present application. Yes, you have no objection.
No objection.
Record that. Counsel for the plaintiff's defendant submitted. The amendment as sought for by the plaintiff is formal in nature. Consider the submission made by the counsel for the respective parties. This court find that the plaintiff only intend to change the address of the defendant company as appearing in page 25 and Annexure B of the present application being the proposed amendment. Considering the above, prayer A to E of the master summon is allowed. J5 disposal.
May there be a direction upon the plaintiff to serve the plaint by way of lodging writ of summons, because now after amendment they'll have to lodge fresh writ of summons. That's not prayed for. Can pass that direction. They can take steps. They can take steps in that regard.
The plaintiff is directed that after the amendment is carried out, after all the formalities along with the amendment is completed, the plaintiff shall take appropriate step for. But you are appearing.
No, he can take that.
No. But there is
Yes, yes.
there will be a
Well, that time there was a problem.
No, not that time. Yes.
It's better,
The plaintiff is directed to take appropriate steps within a week for lodging.
2 weeks, maybe time.
Within 2 weeks from lodging of writ of summons.
Yes.
Here come disposal.
Item E.
I'm the defendant.
Yes.
I'm the plaintiff respondent here. There are two applications. Both GA2 and GA3 is my learned friend's application. GA2 is a section. It's not a Section 8 application, but he's seeking dismissal of my suit. And GA3 is his application.
Dismissal of suit on what ground?
Section 8.
On the ground of existence.
On the ground of
arbitration
an arbitration clause.
Now, GA3 is his application for acceptance of written statement. Though my junior was there, he had taken a direction for filing filing opposition. Opposition has been exchanged, but I leave it to your lordship. I'm not.
May I file my reply?
So both these can be. GA3, my lord, I'll leave it to your lordship.
GA3 may I place first, my lord. GA2 also, my lord, will kindly allow me to complete my submission. I will not take much time,
Coming to GA2, my lord, let GA2.
I will not take much time, my lord.
GA2, if my learned friend makes his submissions, kindly give us 1 day's time to give our reply. The only thing is there's a matter fixed in court 37 at 12:30. Mr. Sen would be there. He'll take notes. So let my learned friend make his submissions in GA2. Well, we'll give our reply on the next day.
Mr. Sen is good enough to dismiss my application as well. I would not put anything past him. So, my lord, may I just place GA3? GA3 is my... GA3, my lord, is my application, my lord, for acceptance of my written statement. The writ of summons, my lord, received on 27th February 2025.
27th February?
27th February 2025.
Correct.
Thereafter, my lord, the initial period has expired. My lord, there's a delay, slight delay, but we are still well within 120 days. We have affirmed the written statement and filed it on 27 June 2025.
27 June?
June 2025. In the interregnum, my lord, there was the court holiday, my lord. We filed it on the reopening date. 9 June, I'm sorry, 9 June 2025, we taken leave of my lord and filed the written statement.
Yes.
Last year. The written statement was affirmed on the last day before the court closing. So Section 4 of the Limitation Act, my lord, I'm entitled to that exemption. My lord, will take my pleadings, my lord, only 58 days delay. My lord, will kindly take my pleadings from para 5 to para 11.
Yes.
It was affirmed on 23rd May 2025. It could not be filed before, my lord, because the court had closed. That was the last date. 9 June, we filed immediately upon reopening. Section 4 of the Limitation Act, my lord, covers me.
Yes.
Well, that's all, my lord. The opposition, my lord, they've said.
I'm not. I leave it to my lord. My lord, even while I was seeking affidavit direction, I had left it to my lord, but I was under instruction to take it.
The plaintiff has filed the defendant has filed the present application being GA Form 3 of 2025, laying for extension of time to file return statement. The defendant says that the writ of summons was served upon the defendant on 27th of March 2020, 27th of February 2025, and the defendant ought to have filed the return statement. By 7th of March 2025. But the defendant could not March 2025. Counsel for the defendant submit that the written statement after receipt of the writ of summons, several conferences were made and instruction were issued to the defendant for providing the documents. And the written statement was prepared on 21st of April 2025. After the preparation of the written statement, the same was sent to the defendant for approval. But in the meantime, the authorized signatory of the defendant transferred from Calcutta and new signatory have been assigned to look after the duties of such loan account, due to which there was a delay and due to which the plaintiff could not file the written statement within 30. Defendant could not file the written statement within 30 days, but ultimately on 9th of when it was affirmed 9th June.
23rd May 2025.
Ultimately on 23rd of June May 2025, the written statement was affirmed.
Thereafter.
And on 9th June 2025, with the leave of this court, the defendant has submitted the written statement in the department. Counsel for the defendant submitted. The plaintiff has filed, the defendant has filed the written statement within the outer period of 120 days and prayed for acceptance of the written statement. Per contra, an advocate appearing for the defendant raised objection and filed the affidavit in opposition, stating that though the defendant has received the writ of summons on 27th of February 2025, but has not shown any cause why the defendant has not filed the written statement within a period of 30 days. The counsel for the defendant submitted that the cost shown in the application not shown will be counsel for the defendant pays for rejection of the application. Had the learned counsel for the respective parties peruse the materials on record, this court find that admittedly the defendant has not filed the written statement within a period of 30 days, but has affirmed the written statement on 23rd of May 2025 and has filed the same in the department with the leave of this court within the outer period of 120 days. Considering the above, this court find that the defendant is given one opportunity to file the written statement. Accordingly, the written statement filed by the defendant is accepted, subject to payment of cost of rupees 5,000 in the department. Rupees 5,000 in the department.
My lord, will kindly consider, my lord, 58 days delay only.
Your company.
My lord, I'm
2,000 to the State High Court Legal Service Authority within a week from date. Full stop. The department is directed to accept the written statement subject to scrutiny by the department. Full stop. I have served the copy.
Yes, no, that's part of my application. Will serve also with all the compliances. Will serve. My lord, it's already. I'm sorry, my lord. It's already served, subject to correction. We've already served under instructions. I'm sorry. Already served.
It's been served.
Okay. The counsel for the plaintiff submitted that the plaintiff defendant has already served the copy of the written statement. In view of the above, GA Com 3 of 2025 is disposed.
My lord, GA2, my lord, will kindly take up.
Yes.
Just short matter after after item 6, my lord, I don't have much to submit. It's a section 8 application. I've taken out an application under section 8, read with
What is
section
your
5.
prayer?
My lord, for dismissal of the suit.
Why?
On the ground of existence of an arbitration clause which has not been disputed. Number 1, section 5, my lord, proscribes any judicial authority. My lord, was Mr. Banerjee has done half my job for me today. Mr. Shatarup Banerjee, my lord. My lord, here section 5 proscribes this honorable court from taking up any matter which is covered under an arbitration clause. In the plaint, may I just indicate in very short, my lord, the plaint case. The plaint case is the plaintiff had availed credit facilities from me. My lord, I'm a non-banking financial company. I had advanced credit facilities to the plaintiff. They had enjoyed the facilities for a particular period of time under a loan agreement. A loan agreement admittedly entered into. No dispute as to signatory, party, nothing. That if the plaintiff before my lord is admittedly a party and a signatory to the loan agreement. The loan agreement contained an arbitration clause. The loan agreement, thereafter the entire loan was repaid. There was a closure of the loan agreement. After the closure, the plaintiff suddenly becomes wiser and decides, no, our company, the non-banking financial company, has overcharged interest. The suit is a claim for money on account of excess interest that has allegedly been charged by my client on the plaintiff. This is a sum and substance. No allegation of fraud, no allegation of anything else. Admittedly, the plaintiff proceeds on a contractual dispute. The plaintiff says, number 1, the grounds that are taken by the plaintiff, because they have a pleading disclosing the arbitration clause. They've relied upon the agreement. They've also pleaded. They are saying it doesn't apply for 2 reasons. Number 1, that the arbitration clause and the arbitration agreement between the parties is unenforceable on account of there being a unilateral appointment clause, which perhaps cannot be gone into by this court at this point of time. If they take out a section 11 application, perhaps that will be considered. Number 2, that the plaintiff proceeds on violation of public law in the form of RBI guidelines. They don't specify which guidelines, they don't annex those guidelines to the plaint, but they say that there's been violation of RBI guidelines by my client. On that ground, an arbitral forum under the loan agreement is not the proper forum to adjudicate the disputes. It has to be by way of a civil court or this honorable court. Number 3, they also state that the arbitration clause does not cover the disputes since the loan agreement has been closed. They've made full payment. Thereafter, the arbitration clause will not apply to the disputes. Since there is a no due certificate admittedly issued by me to the plaintiff, there can be no further existence of the arbitration clause. These are the 3 grounds on which the plaintiff proceeds to.
The third ground?
Third ground, last ground which I just stated, the loan agreement was for a particular period of time. The plaintiff has admittedly closed it. They've made full payment. I've issued a no due certificate. Admitted case. They are saying since the loan agreement was to the loan agreement was subsisting till the time the loan account was closed. After closure of the loan account, the arbitration clause will not apply. I will show that is expressly contrary to the arbitration agreement. My contentions are simple. The arbitration clause is a separate agreement between the parties. The substantive agreement need not be looked at. Number 2, in the arbitration clause, my lord, if I place it, I'll show, my lord.
If you are given the no dues,
yes, my lord. Yes, my lord.
So,
I have no claims against the plaintiff. It is a plaintiff who's come.
okay.
After closure, the plaintiff has realized, oh, I have paid too much. And they've come forward claiming refund of excess interest. This is their case. Perhaps a good case on merits. I do not stand in the way. However, that has to be adjudicated by the proper forum.
Now, if you admit, then I will send you
No,
to the
no.
mediation.
Well, possibly
they are
not.
claiming for-
They've exhausted pre-institution mediation.
They are claiming for 3 crore. I am sending you to the mediation.
No,
Settle it.
No, it was already there was pre-institution mediation, my lord. It's a complete afterthought. I'll show if my lord takes up the merits of the matter. It's a complete afterthought. After closure of the loan account, after no due certificate, plaintiff comes forward with a claim. I've paid excess.
Go before the mediation. Settle it.
No, my lord, perhaps instead of mediator, my lord, let us go before the arbitrator. Is my submission. My lord, will kindly consider just a few documents. I won't take much time. My lord, the loan agreement starts at page 9. Of my application, GA2, my lord. Page 9, the loan agreement starts.
Yes.
My lord, we'll see the names of the parties at page 11.
Yes, agreement is not denied.
Admitted. I'm only taking because this is relied upon in the plain. The arbitration clause is at page 27. Page 27, clause 22. May I just quickly place this, my lord? My lord has page 27.
Yes, yes. Yes,
page
you already
27.
argued on
Yes,
the
my lord, I place this at the ad interim stage. My lord, here, my lord, only will kindly only consider the first line, 22A, if any dispute, disagreement, difference arise between the parties, that includes the plaintiff, during the subsistence of the loan documents and or thereafter. My lord, will kindly note this word because this is the stand taken by them. My lord, it will be referred to arbitration. I'm not taking, my lord, through the entire agreement. My lord, will kindly take the fourth last line from the bottom. The sentence starting with the place of arbitration, my lord, has that is New Delhi. My lord, will kindly have a note of this because this is also a ground for my seeking rejection of claim.
Where?
My lord, the sentence towards the middle of that clause, 4 lines from the bottom. 4 lines from the bottom, the sentence starting with the place of arbitration shall be New Delhi. My lord, has that? My lord, may I just place from the start? It will be easier.
Yes, place of New
Place will be New Delhi.
Yes.
Now, my lord, this loan agreement, like any other finance facility, my lord, has a schedule which contains, my lord, the particulars of this particular loan that starts at page 29, if my lord kindly comes to. Page 29.
Yes.
29, my lord, will kindly see the names of the borrowers are there. The plaintiff is the borrower. I am not taking, my lord, through that. My lord, will directly come to page 32. Page 32, my lord, there's an exclusive jurisdiction clause.
Yes.
Exclusive jurisdiction, New Delhi. Place of arbitration, New Delhi. Thereafter, place of execution is Kolkata, but the jurisdiction clause vested in the agreement is New Delhi. And Malloy, kindly note, place of arbitration is also New Delhi. This is important because the ground taken by the plaintiff to avoid Delhi as the territorial seat, Malloy, is that no part of cause of action arose in Delhi.
Why it is, if the execution in Kolkata and all transaction in Kolkata, why
my client's registered office is in Delhi? And this is agreed to. This is agreed to. And the arbitration clause, Malloy, kindly note, it is one thing for section 20 of the CPC to avoid this forum selection clause. But arbitration clauses, specifically the Supreme Court has now held, and Malloy is aware of the line of cases, it does not matter where the cause of action arose. It is only the place of arbitration agreed upon by the parties which has jurisdiction. I am relying upon the arbitration clause here. Arbitration clause says place of arbitration is Delhi. That is the be all and end all. That is my submission. In the SMOBIL, the judgment of Justice Nariman now holds where section 20 cause of action arises is irrelevant for arbitration. It is only the agreed seat. This is the seat of arbitration. It is New Delhi. Now, Malad will kindly see. Apart from that, I will also show Malad a part of cause of action has arisen in Delhi. The plaintiff has written to my client in New Delhi. Malad will now kindly consider the plaint only a couple of paragraphs just as to their defense.
Page 32.
32, those two clauses, Malad, exclusive jurisdiction New Delhi, place of arbitration New Delhi, clause 19 and 20.
Yes.
19 and 20. Just for that. And this is signed by them, accepted by them. They're relying upon this. Now, to avoid this, Malad will kindly take the plaint. The plaint is quite well drafted, Malad. They've taken all the pleas, but perhaps they won't be tenable in law. Malad will kindly take page 41 onwards is the plaint. Malad, page 43, Malad will kindly note they refer to the loan agreement. They accept it. They rely upon it. Page 43.
Yes.
Thereafter, Malad, only a couple of paragraphs. Malad will kindly see their pleading at page 57. Page 57. Well, para 49. May I just please?
Yes.
Para 49 is their pleading as to cause of action. This is very crucial, Malad. The cause of action of the present suit arose due to the defendant realize excessive interest and damages suffered by the plaintiff. This is also at the time of the plaintiff's repayment of the entire dues and the defendant's refusal to issue no due certificate till the month of May 2022. Till that time, the plaintiff's account was operational with the defendant and the plaintiff was not made aware of the interest rate increase. That apart, the plaintiff at different points of time had suffered loss and damages because of the defendant's, kindly notes the words, breach of contract, which arose on different dates till such time the plaintiff availed of the loan till 20th May 2022. Admitted cause of action pleading is breach of contract.
Yes.
No fraud, no non-signatory, nothing of that sort. Well, I will now kindly come to page 58. the forum selection clause pleading, my lord, page 51. The loan agreement admittedly has been executed in Kolkata at the defendant's then office at Bangur BFL estate. I don't know where they get this admission from. The agreement does not specify where exactly the agreement was entered into, whether it was within the jurisdiction of this honorable court or some other court in Calcutta. This is not an admitted fact. Kolkata, Chorangiri, so and so within the jurisdiction. The loan amount was disbursed from the defendant's associate office within the jurisdiction of this honorable court. The repayment of the loan has also taken place in Kolkata from the plaintiff's said office, which is situated within the jurisdiction of this honorable court, and has been received by the defendant at its aforesaid office within the jurisdiction of this honorable court. The present office of the defendant is also situated within the jurisdiction of this honorable court, though the cost title says, Mala, this is only a regional office, not the registered office. In view thereof, the plaintiff's cause of action for filing the suit has arisen within the jurisdiction of this honorable court. Therefore, even though in terms of the loan agreement, the courts of New Delhi will have jurisdiction to entertain the disputes relating to any matter or issue under or pursuant to the loan transaction, inasmuch as no part of the plaintiff's cause of action has arisen in New Delhi, such forum selection clause is of no consequence, so and so. Perfectly good pleadings for a suit. Not good pleadings when there is an arbitration clause. Arbitration divests this honorable court of all powers, and the place of arbitration once decided has to be, or rather the proceedings have to proceed in New Delhi. It doesn't matter where the cause of action arose. Now, my lord, page 59, last paragraph. Page 52, my lord, will kindly take. Plaintiff's cause of action in the present suit arise out of the defendant's breach of various Reserve Bank of India guidelines and directions, apart from, Malad will kindly note, breach of the provisions of the contract. Admitted case. There is a purported arbitration clause in the contract, which does not cover the cause of action forming the subject matter of the suit. The said arbitration clause is also null and void. As per the arbitration clause, the defendant is to appoint, not important, Malad. Thereafter, they just say the arbitration agreement is null and void on the ground of the selection, or rather the appointment procedure prescribed in the arbitration clause being null and void. I am not on that at all. That is not for this honorable court to decide. This is their plaint case. I come to this honorable court, my lord, file this application first and foremost. Before filing written statement, section 8, my lord, allows me to file this application. I come forward. Now, my lord, you kindly see the praise in my application. My lord, we kindly take the master summons. Prayer A is the present. I'll place, my lord, for my lord's convenience. The present suit being CSCOM so and so be dismissed in limine. The plaint in CSCOM so and so be rejected and or returned. My lord, will kindly note. The present suit be stayed. Now, my lord, there's a stand taken by the plaintiff in their affidavit in opposition that I have not sought a prayer for reference of the disputes to arbitration. Number one, I do not need to do so. Secondly, my lord, will kindly take page 6 of my application. Para 8. My lord, will take para 8, the unnumbered paragraph, just one line, just for my lord's satisfaction that I have sought to refer, if any cause of action, to arbitration. In the present case, it is obligatory for this honorable court to refer the parties to arbitration in terms of the arbitration agreement. Just to dispel this notion that I am not seeking to abide by the arbitration clause, specific averment is there. I need not seek reference, because I am not the claimant in this proceeding. I am not saying that there is any amount due and payable to either party. It is for the plaintiff to say, it is for the plaintiff to file a section 11 application, whatever they want to do, that's up to them. They cannot come before this honorable court. Now, my lord, a few judgments. My lord, this is the only stand subject to correction. These two stands are taken in the affidavit in opposition. Just to save time, my lord, I'm not placing the entire affidavit in opposition. My lord, will kindly make a note. There is a letter of 3rd May 2024 in the plaint, which was addressed to my client's office in Delhi, just to satisfy my lord's conscience that a part of cause of action has arisen. The plaintiff himself wrote a letter to my client in New Delhi, not Calcutta. So a part of cause of action has arisen. For what? In respect of this dispute. This is post-closure. Correct. Post-closure, they have written a representation to my client in New Delhi. So they admit that the registered office and the place where my client operates and carries on business is New Delhi. So a part of cause of action has arisen. There's a denial of this in the affidavit opposition. I must just indicate page 9, my lord, will kindly have a note. I'm not bothering my lord with that. Page 9 of the affidavit in opposition, they say that mere writing of a letter does not give rise to cause of action.
Where is the letter?
The letter, my lord, is in the plaint. If my lord kindly takes up the plaint. Second. My lord will take the second volume of the plaint. My lord, I'll give my lord page 179. 179 of the second volume.
Yes.
Well, this is their letter, the plaintiff's advocate writing to my client. My lord, will find India Bulls is the former name of my client. My lord. Here it's different. The first address is New Delhi. So they also recognize this. They admit that in the agreement as well, they've acknowledged that my client's registered office is New Delhi. They write to me there. This is in respect of, this is a reiteration of what they say in the suit. It's effectively a demand justice or a representation. Now, while my lord is at the plaint, my lord will kindly consider one more pleading in the plaint on the ground of public law violation is non-arbitrable. My lord will kindly consider page 43 of my application, that is equivalent to, my lord has the plaint, my lord can have a look from there, page 3, internal page 3 of the plaint, or my lord page 43 of my application, whatever is convenient, my lord.
Yes.
Page 43, my lord, 1 second, I'm sorry, my lord, I'm sorry. My lord, page 52, I'm sorry, my lord. Page 52, I made a mistake. Page 52, para 34 onwards, my lord will find my learned friend's client had filed a writ petition on the ground of these purported public law violations of RBI guidelines. They were unsuccessful. They had made representations thereafter to the National Housing Board, dismissed. After that, they decide to avail of the civil remedies, that is filing this suit. So this ground of public law remedy not being arbitrable is also really an afterthought, because they had already exhausted.
Order, what order?
Malad, there was an order passed by the Honorable Writ Court initially to allow the petitioner or the plaintiff to make a representation before the National Housing Board. That was thereafter challenged and they did not accept that. Eventually, Malad, if I may place 34, 35 and 36, Malad, the National Housing Board finally, after the Writ Court's order, the National Housing Board has also not entertained their disputes. This is a sum and substance, perhaps not relevant at this point of time. Their remedies in public law, if at all, they tried to agitate before the Writ Court. The Writ Court did not entertain. They agitated it before the authority. Authority did not entertain. Thereafter, what do? They could have preferred an appeal from the Writ Court's order. They could have preferred another writ petition if they feel so. They do not do so. They avail the civil remedy, that is arbitration, and they say specifically in their plaint, breach of contract. My lord, there is no decision subject to correction by my learned friend. There is no decision of the Honorable Supreme Court proscribing the arbitrate from going into questions of public law either.
Okay.
My lord, now just a couple of decisions, my lord. I won't take much. My lord, Vidya Drolia, I am formally citing. My lord has seen that already. My lord, I am formally citing, my lord, paragraphs 48, 49, 70 and 139. My lord can kindly note, my lord has read it 100 times. My lord.
Paragraph
48, 49, 70 and 139. Acha, sorry, 2021 2 SCC 1. My lord,
yes.
My lord, now as to their contentions, just two judgments to dispel this contention that I have to pray specifically for reference of disputes to arbitration. My lord, first, a decision of the Honorable Delhi High Court in 2014 SEC Online Del 4015. 4015. My lord, here I'll just indicate what this judgment is about. Here, my lord, the court was considering dismissal. This is a revision bench judgment of the Delhi High Court. Here, the suit was dismissed on the ground that in the written statement there was one averment that there is an arbitration clause and the disputes should be referred to arbitration. That was held to be compliance of Section 8. And the Delhi High Court, the single judge dismissed the suit and thereafter carried up an appeal dismissed. Para 5 to 8, will kindly take. These are the submissions of the parties.
Yes.
Para 5, will kindly. In the written statement file, no specific prayer was made to refer the parties to arbitration. No application was filed. No application was filed under Section 8 of the Arbitration and Conciliation Act. Paragraph 6, highlighting that the written statement was filed before February 24, 2012, the date fixed for return of summons in the suit, and obviously without seeking any time from the court to file a written statement. We know that via the impugned order dated March 3, 2014, the learned single judge has disposed of the suit, referring the parties to arbitration in replication filed by Sharad P. So-and-so under clause 13 of the agreement. This is the order impugned. Now, Mulad will kindly take, para 7, Mulad will kindly take. What was argued before the learned single judge was the effect of an application not being filed under Section 8 of the Arbitration Act by Edelweiss, whereas Sharad so-and-so pleaded that filing of an application under Section 8 of the Arbitration Act was a condition of the parties to be referred to arbitration. Edelweiss took the stand that the requirement of law was to bring it to the notice of the judicial authority in the first statement on the substance of the disputes filed by the defendant that there existed an arbitration clause in the contract between the parties and that the subject matter of the suit, i.e. the cause of action brought was the subject matter of the arbitration agreement, to which response Edelweiss, Sharad so-and-so, responded by taking a stand that in the written statement filed, except for drawing attention of the court to the existence of an arbitration agreement between the parties, no prayer was made that the party should be referred to arbitration. And while so responding, Sharad so-and-so made it clear that the said plea was an alternative to his main argument that Section 8 does not apply, so-and-so. Thereafter, para 8. The view taken by the learned single judge is that the requirement of law under Section 8 is for a party relying upon an arbitration agreement to apply to the court, praying that the parties be referred to arbitration not later than submitting the first statement on the substance of the disputes. The learned single judge has held that the first statement on the substance of the disputes by the defendant could be the written statement. Thereafter, the provision, the merits of the matter are discussed. Para 15, will kindly directly come to. From 5 to 8, the facts of the case are stated. Para 15, will come to. Section 8 does not specify the manner in which the party has to submit its first statement on the substance of the disputes. And normally, with respect to a suit, the first substance of the dispute by the defendant would be the written statement. Thus, if in the written statement filed, it is brought to the notice of the court that there exists an arbitration agreement between the parties which embraces the subject matter of the suit, there would be complete compliance with the mandate of law, and the court would be obliged to refer the parties to arbitration if the plea in the written statement is made good. Here in my written statement as well, that averment is there. I'll satisfy on that. Thereafter, on the facts of the instant case, it may be true that in the written statement filed, a specific prayer has not been made to refer the parties to arbitration, but we have highlighted here and above that in the written statement filed, a preliminary objection has been taken that the suit is barred by law in view of the arbitration agreement. The written statement filed is with strings attached by challenging the maintainability of the suit in view of the arbitration clause, and therefore in such circumstances the said objection taken by Edelweiss contained in the written statement could be treated as an application under Section 8. I have done both things. I have filed an application and also in my written statement that plea is there. Now, my lord, one more judgment. The Honorable Telangana High Court, on this ground, as to whether filing of a 711 is sustainable instead of a specific application for reference. Citation. Well, 2024 SEC online, Telangana. 2024 SEC online TS 1618. Well, this was a Section 11 application wherein the claimant who was seeking reference my lord, stated that there was a 711 application filed before the court, or the civil court, wherein the arbitration clause was referred to, and on that basis, the suit was sought to be dismissed. The Section 11 court allows the prayer for appointment of arbitrator, taking into cognizance that 711 application. So that is permitted. My lord, will kindly have a look at paragraph 9 and 10. Section 8, may I just place 9 and 10 very quickly? Section 8 of the Act requires a party to bring to the notice of the court that an arbitration agreement between the party exists. The object of Section 8 of the Act is to bring the matter in relation to the existence of the arbitration agreement to the notice of the court. The Supreme Court in Sundaram Fine and Supra dealt with the issue as to approach of the trial court once an application before it under Section 8 is filed. In paragraph 13, it has been held so and so. I'm not reading that. I'm placing reliance upon it. I'm not placing it separately. Paragraph 10. The requirement contained under Section 8 is satisfied in the facts of the case by filing an application, namely under Order 7, Rule 11, and it was brought to the notice of the court that the arbitration agreement exists between the parties. The applicant has not submitted itself to the jurisdiction of the court. Therefore, in the peculiar facts of the case, it cannot be held that the applicant has not complied with the mandate of Section 8. Therefore, the contention of the applicant is not entitled to invoke Section 11, is misconceived, so and so, an arbitrator is appointed. My lord, last but not least, my lord, will kindly consider my lord's own judgment in Titagore Rail Systems versus Yes Bank, delivered on 13 December 2024, where, my lord, I was unfortunate to be on the losing end, my lord, where we suffered an order of dismissal of the suit on both grounds. Number one, arbitration agreement. Number two, place of arbitration, my lord, outside. My lord, here, just I need not take my lord through my lord's own order, para 37, 42, and 42 to 44.
37,
37, 42 to 44.
42 to
44. And my lord, here, just one other submission. My lord, here a dispute was raised solely on the ground of an office memorandum, which directed the defendant to do XYZ. Again, the question of public law dispute not being arbitrable was raised. My lord has rejected that. My lord has not referred it to arbitration, has dismissed the suit. This was primarily dismissed on the ground of forum selection clause, primarily. But my lord, here this question was also argued. This same contention that is being made today was argued. My lord can consider the submission of the plaintiff. My lord, I need not place the entire thing. My lord will recall. I'll just indicate the paragraph just for my lord's satisfaction. Lord, para 24, my lord, has framed the issues, and thereafter the decision is para 37, 42, and 44. So, my lord, here as well, this decision was unchallenged. I can say that with some authority. This was not challenged, and the suit has been dismissed. No further suit has been preferred. No reference to arbitration has been made. So, my lord, on that, and my lord, formally, though I am not carrying it today, Avitel, which was cited by Mr. Banerjee's client, my lord, Mr. Banerjee in that item 6 matter, my lord, that also squarely covers my case. That, my lord, formally, which citations are Avitel is 2024 SEC online SC 345. I am formally citing.
2024?
2024 SEC online SC 345. Yes.
Yes.
No, the Avitel, that's all.
Thank
you. Kindly refer the matter to arbitration.
Thank
you. Oblige me.
My lord, while I'm tempted to respond, my lord, I'm under instructions to keep the matter on any day, my lord, between 6th of August, my lord, and 29th of August, any day between 6th of August and 29th.
The defendant has filed an application in GA3.
GA2 is my
disposal. GA2, form of 2025, praying for dismissal of the suit, or in the alternative, dismissal of the suit. Counsel for the defendant has concluded his argument. Counsel for the plaintiff raised for time according cases. Let the matter appear on 12th August.
Obliged.
I'm deeply obliged.
Obliged.
under the same heading. Yes.
Lord, I appear for the defendant. I'm being led by Mr. Shuddhajota Banerjee. He's busy with another matter in the court. He has intimated the same to Mr. Gupta also.
What is the hearing?
Yes, my lord, on the last occasion, my lord, GA2, my lord, is there application for section 10 and also for dismissal of the suit?
Lord, I pray for not today.
My lord, only my appear in opposition, my lord, to their GA2, my lord, that may be taken up.
You are for the plaintiff.
Yes, my lord.
Affidavit in
Opposition, my lord, GA2. My lord, I've
Affidavit in
already served them, my lord, it's only for formally taking it under.
affidavit in opposition filed by the plaintiff in connection with J2 of 2021. 2021. Yeah. Be kept with the record. Counsel for the defendant. Praise for time. According to case is adjourned. Let the matter appear on 6th August.
With respect to the application which was intended to be filed with respect to the presentation of claim that happened in the body. But to be attempted, now the department is saying that unless there is a leave which is recorded.
My lord, I also have a similar
Now the
prayer, my lord.
copies,
It's a
now the
plain, my lord, legible copies of.
I shall file and so.
Leave is granted to file the general application in the urgent matter. Due
My
to
lord,
the urgency.
my lord, this is a plaint, my lord. I'm faced with a similar problem, my lord. Several pages, my lord. It's a legible annexure. However, it contains, my lord, signatures in Bengali of laborers. My lord, I'm praying for leave. The department has intimated my advocate on record, my lord, that leave has to be granted so that my lord,
alright.
translation can be dispensed with in respect of those signatures.
The department is having this duty.
My lord, they have asked for a leave from your lordship, my lord. Otherwise, my lord, it is not possible to translate only the signatures if lordship will see. The names are in English. Page number 126 onwards, and my lord, that.
Let the department do all the things, only file sent to the judge, they will dictate the order. Only signature in Bangla.
Yes, my lord. Some of the signatures, not even all, lordship.
Yes, leave is
126
granted to the plaintiff. No, department is directed to accept the plaint with the signatures of
the laborers, lord.
Of the employees / laborers, which appearing in the Bangla language.
Grateful, my lord. Great.
My lord, the very next matter, my lord, volume
Which one?
Item number
Cave metal.
item number 10, ma'am.
Ah,
Ticket on one.
no, not today. Not today.
So that the court is functioning tomorrow. I have some difficulty if the matter appears.
No, not tomorrow. Monday.
So,
I have annexed all your lordship. I am showing your lordship your lordship the tax receipts.
Earlier you shown that is also D.
No, that is D and E both. Because at that point of time, land was there. We constructed, your lordship, we converted. Now, your lordship, in that particular plot, building has come. Now, we distributed, your lordship, regarding the flats. The front side flat, page 30, Umia Shankar, Chaganlal Dave's name will mention. This is Schedule D property.
How you can say the front side?
Lordship, that I could not get it, your lordship. I asked him, but they have said, your lordship, in this way, your lordship, they have done. Okay. Page 30, your lordship, thereafter, your lordship, kindly sees page 34.
Yes.
Earlier, it was UBL identified number 6 by 31261, and now your lordship kindly sees page 34. This is Schedule E. Name is mentioned, Umia Shankar, Chaganlal Dave, and there is a, your lordship, just below that, there is a column. Zone number, ward number, old property number, new property number, ULB identification number. 6 by 3 by 262.
Yes.
And earlier it was 6 by 3 by 261.
Where is the old is not there?
No, not required. ULB identification number is required.
Okay.
Because how they, your lordship, in Anand, your lordship, they used to do it. Apart from that, your lordship kindly sees, I have also disclosed, your lordship, the others which are not the scheduled property which has been distributed earlier. Page 38.
Yes.
Dr. Yogesh Bhai, Umia Shankar Dave. So not required, your lordship, this flat. I have given your lordship, for your lordship satisfaction. I have given everything 38, then 42, then 46. I have given your lordship everything for your lordship satisfaction.
Yes.
So I tried, your lordship, my level best. We are on the same line, your lordship. He is the defendant, your lordship, who is.
Where is the judgment of the Supreme Court?
The judgment of the Honorable Supreme Court. Yes, your lordship, kindly take.
Mukesh versus Madhya Pradesh.
Yes.
Mukesh versus Madhya Pradesh.
Yes, yes. Para number ta bola. 13th. Lordship can consider from page number 20, paragraph 13 onwards. And last page, page 22, your lordship, the compromise decree, your lordship, has been mentioned. Lordship can take page 21, last paragraph. From the above, it is apparent that stamp duty is not chargeable on an order or decree of the court, as the same does not fall within the documents mentioned in Schedule 1 or 1A, read with Section 3 of the Indian Stamps Act, although the collector of stamp determine the stamp for the subject land as per Article 22 of Schedule IA of the Indian Stamps Act, which states about conveyance. In this case, we have already held that the compromise decree does not fall under the instrument mentioned in the schedule, and that it only asserts the pre-existing rights. Therefore, in the facts of the case, the concerned decree will not operate as a conveyance, as no right is transferred, and the same does not require any payment of stamp duty, since the appellant has only asserted the pre-existing right and no new right was created through the consent decree. The document pertaining to mutation of the subject land is not liable for the stamp duty. Your Lordship, this is the.
Okay. Okay, I'll pass out.
I'm grateful. And any query, your Lordship?
Hearing concluded.
No, not.
Yes.
I'm grateful.
To my lord, I'm for the alleged contempt, my lord.
Yes.
Contempt arises out of an order dated 16 January 2025, my lord, whereby I was directed to file certain documents in a sealed cover, my lord. I'm filing the same in the court. And my lord,
My lord's order is at page 57.
57.
That 58 is the list, my lord. The original ta kote ache দিয়ে দিয়েছে
sealed
Yes.
cover.
মানে তো বলো
আমি খুলে রেখেছি পেয়েছিস মোটামুটি
I'll tell my client to look into this once. My lord's consideration also. The list is here at page 58.
Everything is according to the list appearing in the order.
আরে ভাই আমরা কি বুঝতে পারবো আমি এটাই বুঝবে ভাই দুটো স্যাংশন প্ল্যান completion certificate. হয়তো হারিয়ে গেছে position certificate that's the position certificate storage connection mutation
Okay, I am taking on record and I am giving liberty to you. Inspect this document. Inspect the document. I am fixing next week. In presence of the court officer, you.
Yes, I will have it with the my lord's office.
The only request will be that after the inspection, the same documents be kept in the record of the suit.
Correct.
Yes. Yes. It should be the maybe the register original side may be better. Whatever in the court or whatever. It has to be.
In terms of the order passed, you have filed the contempt application. The contempt application.
Yes, contempt.
The
contempt.
You are for the plaintiff.
No,
you are for the defendant.
Plaintiff number 3. Plaintiff number 3.
And the
You are for the.
I am for the plaintiff number 2 in the suit. Plaintiff number 2 in the suit, co-executor.
Plaintiff number 2 has filed the present contempt application. Against whom?
She is not a party. She is one of the beneficiary of the will.
Against one of the beneficiary.
Mothers.
You made a 3 persons as a contemner. You made.
Because we were not aware in whose custody it's there.
Okay, क्या बोला?
The contempt number
application. नहीं, against छोड़ दो. On the allegation of non-compliance. On the allegation of non-compliance of the order passed by this court dated 16 January 2025, wherein this court has directed for production of original document before this court. Police. In compliance with the order dated 16 January 2025, comma, the beneficiary, namely, what is the name? Client's
Puspa Kajaria.
With the one.
Contempt number 1.
Puspa Kajaria, within bracket, the alleged contempt number 1, has filed 8 numbers of 8 documents.
8 documents, my lord.
8 documents in a sealed cover. And 8 documents in original in sealed cover. So, let the same police. This court has opened and the sealed cover is open and found that several original documents are lying in the have been kept in the sealed cover. Let the same be kept with the record. Police. The petitioner, the plaintiff number 2, is at liberty to inspect this document before the registrar original site.
Registrar
original site. Within a week from date. Police. After the inspection of this document, within a week from this, let the matter appear on.
I will take inspection within a week.
Within a week, let the matter appear on 22nd of August 27.
It may retain the position.
Let the matter appear on the same heading under the heading 2 minutes. Let the matter appear under the same heading.
Deep level.
सील का उसमें डाल दो. डाल के सील करो. सील करके रजिस्ट्रार के पास भेजो.
We'll go to the registrar. No, Mr. Wilson.
Yes.
No, I'm very sorry, my lord, not done to disturb your lordship mid-list, my lord. My lord, there was a supplementary list published at 141. My lord, we didn't know. Otherwise, we would have been here at
141, no?
Yes, 141 supplementary.
Whatever, I have followed the Chief Justice direction.
Yes, yes, yes.
I got the direction at 1:10 or 1:15 p.m. Immediately, I directed to
Previously, what
supplement.
used to happen, my lord, when my lord, in our younger days, my lord, before computerization, plaintiff's advocate on record would be informed by the Chief Justice that this is the assignment. Now, my lord, it comes up straight, my lord, in the website. So, my lord, we didn't realize. At my lord, 2:05, my lord, I was told. I was not in court. I was in my chamber in Old Post Office Street, came running. My lord, this is a very checkered history. Your lordship knows the first part. We
Now, what
filed
is the urgency now?
my lord, meetings tomorrow. And by trickery and criminal contempt, the matter has been forced, my lord, to be recused by a learned judge.
What has happened in the appeal court?
Appeal court, my lord, we lost because one document we had not produced that was shown, and appeal court says that no. Three, I read the appeal court's order. 3 observations against my client. Number 1 is you should not have issued the letter. You could have approached the committee, and this is not done in a club. But on all other findings, there is no finding against us. My lord, after that, we, my lord, requested for a settlement, and the special board meeting was deferred. Now, we agreed before the division bench that special board meeting deferred by some time and affidavit directions matter to be heard by learned single judge. We mentioned before, lordship released the matter. Immediately, my lord mentioned, got it listed. I argued for 2 days. And Monday, Tuesday. And Wednesday, Mr. Mitra argued whole morning. But now, by now, we have affidavits also. And we were able to show that the whole thing is, my lord, mala fide and contrary to the rules. They went, my lord, got a defendant who have never appeared in the matter to tell the learned judge, we have no faith in you. You release the matter. And the learned judge was pleased to pass an order. My lord, it's in your lordship, the most distasteful order, my lord, the most distasteful request to a court I have seen in my 23 plus years. And lordship, my lord, before closing hearing, after hearing for better part of 4 days, was pleased to release the matter. We immediately applied for assignment, and it's come before your lordship. My lord, we had no way of knowing. 141 it came. My lord, by the time we noticed it and called each other up and came running, my lord, it was called on. This is the situation. My lord, if your lordship sees the order
Who is for the
once-
other side?
Other side, my lord, I have, my lord, the fact of the matter is, I have, my lord, now, I hope the other side at least doesn't come while during the time I am here, because what I will say is unparliamentary. My lord, please have a look at the release order of Justice Mukherjee. তোমার কাছে আছে? Please have a look at just read the release order once. After 5 days of hearing, my lord, this is in criminal contempt of court. I'll place it, my lord. On 26th of June, when GA number 3 was in the list of this bench, prior to taking up such application, had expressed its view as to whether application should be taken up by this bench, as the plaintiff is an advocate with whom the judge concerned had professional association during his days in the bar. Moreover, for a brief period of time, the judge concerned was also an honorary member of the defendant number 1 club, but not so since 1st April 24. At that point of time, the defendants, through their counsel, as also the plaintiff, expressed no objection on the matter being taken up by this bench. The application was heard on 26 June 25 and an order was passed. Subsequently, the order was appealed against, pursuant to which further orders were passed in the application on 30th June and 18th July. None of the parties expressed any concern regarding this bench taking up the matter, even on the subsequent days. Another application, being GA number 4, was filed before this bench, in which directions for filing of affidavits were given in the presence of the parties on 23rd July. None of the parties expressed any concern even then. GA number 1 was mentioned and brought into the list on 28 July 25, when none of the parties objected to this bench taking up the said application. GA number 1 has been heard at length on 28 July, 29 July, and also today, 30th July, for a greater part of the first half of this court. None of the parties expressed any concern till the recess. After recess, on behalf of the defendant number 5, it was submitted that this bench should recuse the matter, as the said defendant lacks in confidence of this bench taking up the matter. It is also submitted that the said defendant did not have the occasion to represent prior to this day, though the defendant is an executive committee member of the defendant number 1 and part of the members relationship committee constituted by the executive committee to deal with the plaintiff's case and had actively participated in proceedings from day 1. It is unfortunate that when courts are hard pressed, that time the defendant number 1 should have at the very threshold raised his objection, which could have avoided wastage of judicial time in taking up this matter by this bench. The plaintiff says that this is a deliberate ploy to get the matter released from this bench to cause prejudice to the plaintiff, as it will be hard to get the matter assigned before 2nd August 25 for hearing of applications, as the same are required to be heard prior to 2nd August 25 when the meeting of the special board is fixed. And the chain of events and conduct of the defendants show that in a predetermined notion, the defendants intend to expel the plaintiff from the club without affording the plaintiff any opportunity to have the matter heard before this court. The release of the matter has been sought for in a designed manner to render the matter infructuous. Although it is not the practice of courts to recuse from matters after the same has been taken up for a considerable period of time after getting it clarified from the parties, but a doubt expressed by a party persuades the court to release the matter. This bench therefore records the reasons for recusing the matter as stated above. Released. Original minutes book is to be kept. Loco copies shall be kept in the custody. My lord, meeting is tomorrow, which is why, my lord, judgment would have come before that, which is why this, my lord, pernicious attempt was made. Now, matter had gone to the division bench. Before the division bench, my lord, we had agreed that date of special meeting would be, special board meeting would be tomorrow. We'll appear and affidavits and hearing before the learned single judge. So they were aware who the learned single judge was, because it's from, my lord, an appeal from the same learned single judge's order. There also they had not expressed. Only when, my lord, they realized, only when, let me not get carried away, only when, my lord, the clients realized that the learned judge, after appreciating the affidavits, is against them, this pernicious attempt, which is, my lord, in criminal contempt of court, was undertaken.
Yes.
My lord, your lordships have been, my lord, greatly, my lord, greatly, if I may say, undermined by this, my lord, behavior of, my lord, those who are responsible for this sort of a pernicious attempt on a court. A judge hearing the matter for 5 minutes, please see the sequence. We go before the learned judge. Learned judge passes an order saying special board not to sit, but same meeting to be held, matter to be settled. From that they appeal. Before the appeal court, both sides agree that very well, meeting will be held on a particular date and GA will be decided before that. Obviously, before the same learned judge. We go back and mention, we first go to your lordship, mention the matter. Your lordship releases it, mention for listing. And when, my lord, we tried to get the matter heard, first they say, I have a problem. Then they send a lady to take an adjournment. Then they come and, my lord, do this. Then the judges say, sorry. Senior comes and says, I'm not free till Thursday. Sorry, I'm going to hear the matter and see if I can deliver judgment. Matter is heard. Judgment would have come. Whether against me, whether in my favor, I don't know. I can't get into the learned judge's mind. His lordship made no observation. But from the questions, my lord, it became very clear that his lordship, my lord, found some anomaly in the minute book, etc. And then Thursday after, my lord, they finished submissions. A new advocate is brought. 2 new advocates are brought for the first time. For defendants, for committee members who have never appeared. They sit in court from the morning. Then after lunch, my lord, they say recuse yourself. This is, my lord, the conduct. Now my lord, today is a Friday. My lord, tomorrow is a court day. If your lordship, my lord, takes it up, I'll
Is the
start.
time of the meeting tomorrow?
11:30.
By consent, or your lordship has seen the division.
What
bench order?
consent?
May I
You
see
are
the division
you
bench?
are a party to criminal
Mr.
contempt.
Chaudhary has made a lot of
Please,
submissions.
please,
I
please,
did not.
please.
I did not object.
The whole court,
This court
Several
didn't want to
prejudicial
be a
arguments.
party
the
of any
whole
of the
court knows what you have done.
Well, extremely prejudicial arguments have been made. I'm not saying anything. Your has the division bench order been shown to your lordship? Well, let me just place it.
No,
We did not
so
know.
tomorrow what meeting is
Meeting
there?
is happening by consent of parties. By consent, that's the thing, Mala. That's not been shown to you.
Please see the order.
Mala, papers are coming. Your lordship will give us 2 minutes. Mala, the papers are coming. I can read out the division bench order, my lord.
অফিস থেকে ফাইলটা আনাও না চট করে এখানে আমার দিকে না তাকিয়ে অফিস বলো অফিস আজকে বলো
My lord, an order was passed on 16th of July by the division bench. I'll tell you, lordship, what had happened. After your lordship's order, from your lordship's order, an appeal had been preferred. The division bench did not interfere with your lordship's order. It was confirmed. There are several observations. I'll come to that later on. The day the division bench passed the order, my learned friend, they filed an application before the learned single judge. Your lordship was not taking the determination anymore, so before the other single judge. Their application was for constitution of a special board. Your lordship will remember, my lord, this was a matter where, my lord, there was suspension, and from that the special board to go to. So they file an application. Their specific prayers are for appointment for the special board to be formed afresh. In that application, my lord,
this is the
instead
order.
of well, this is the copy of the order being handed over to you. This is the division bench order. But before your lordship takes the division bench order, my lord, in that application for appointment of a for freshly appointment of a special board, my lord, the learned single judge directed the special board to be stayed and also that an informal meeting take place. The order was passed on a Thursday, on a Friday, and the special board meeting was on a Saturday. So, my lord, with deference to the court's order, my lord, we did not go ahead with the special board meeting and we preferred an appeal. In the appeal, this is the order which has been passed. Your lordship, my lord, they withdrew. In fact, the fact that the informal meeting will happen, they accepted to go for.
Where did I withdraw?
I will show it, my lord.
Why are you misleading the court?
The order speaks for itself, my lord. Just because Mr. Chaudhary will raise his voice, that doesn't make a difference. My lord, we'll see the order. The appeal is directed against the order of 26 June 2025 passed by the learned judge in this court in GA3 filed by so-and-so. The respondent number 1, a member and former president of Calcutta Swimming Club, filed CS 13 challenging the suspension notice issued to him by the management of the club. The plaintiff prayed for ad interim order to restrain the management of the club from giving any effect to the suspension notice. Upon such prayer not being allowed and only direction of exchange of affidavits being given by the learned single judge, the plaintiff preferred an appeal being APOT 78. That appeal was disposed of by this bench vide judgment and order dated 24th June 2025. We did not interfere with the order of the learned single judge, and we directed that the plaintiff's application should be heard and decided by the learned single judge upon exchange of affidavits. It appears that thereafter the plaintiff filed another application before the learned single judge being GA3. This is the application I was talking about. If your lordship sees the prayers prayer B, a direction upon the respondent number 1 to constitute a special board afresh and initiate the meeting as prescribed under 22G. This is their prayer. My lord, there are several prayers on the same line. Then, my lord, upon that application being moved, the impugned order was passed by the learned single judge. After recording submission of parties, the learned judge passed the following order. After hearing the parties and in the backdrop of the orders passed by the learned single judge and the honorable division bench, considered in the light of the above records, I am of the prima facie view that the dispute can be resolved in an honorable manner
by parties on the basis of discussion between members, if necessary, and with the intervention of advocates. On the allegation that the former president has questioned accounts, my lord, if your lordship takes, my lord, the last paragraph, in the aforesaid circumstances, to enable amicable resolution of the dispute to materialize, this court feels that instead of holding a special board meeting on 28 June at 11:30, the same should be adjourned, and instead thereof, at the same time and same venue, an informal meeting may take place. Well, this is the order which was passed by the single judge. From that, we preferred an appeal. Now, your lordship will see, being aggrieved, the secretary of the club has come up by way of this appeal. It is submitted that on behalf of the appellant, the learned judge ought not to have, in effect, stayed the holding of the special board meeting scheduled to be held on 28 June. That runs counter to the judgment and order of 24th June 2025 passed by the division bench disposing of the appeal. We are of the view that we need not go into these issues. The informal meeting that was held pursuant to the desire of the single judge has not yielded any positive result. In a sense, the impugned order has worked itself. Now the plaintiff himself has applied for an order directing that the special board meeting be held after the board is reconstituted. The parties agree that the following order may be passed. Accordingly, by consent of parties, the following order is passed. We fix, well, the division bench fixes 2nd August 2025, Saturday, 11:30 as the date and time for holding the special board meeting. No further notice of the meeting shall be issued to the parties in the proceeding. The appellant will ensure that all concerned who are not present before us receive adequate notice. That is the ex-precedents, my lord. The management of the club shall reconstitute the special board in accordance with Rule 22. That has been done. The respondent plaintiff shall nominate 3 members of the club to represent him at the special board meeting within 7 days and communicate to the... That has also been done. The club shall make available all papers and documents to the plaintiff as will be made available to the special board. That has also been done. The special board shall conduct the proceeding on 2nd August strictly in accordance with rules and bylaws of the club. Nothing further remains in this appeal. The appeal and the connected application is thus disposed of. The learned counsel rightly say nothing remains in GA3. GA3 was the prayer for special board. Finally, it got disposed of. Finally. Pending before the single judge. Accordingly, GA3 is treated on the days list and is disposed of. Well, at GA1, there was a direction to file affidavits that had expired. So they took time to extend. That is all. Insofar as GA1 is concerned, while disposing of APOT so-and-so by our order of 24th June, we had extended time for filing affidavits. The respondents before the learned single judge say that they have already filed their affidavits. That is us. The plaintiff shall be at liberty to file his reply in connection with GA1 in course of the week with a copy to the learned advocates. Where is there any direction that the GA1 has to be heard out before 2nd? In fact, my lord, the 2nd August meeting is by consent of parties. It's by contract between the parties. It's a court's order. Whatever Mr. Chaudhary is saying, nothing is there in the order.
What did I say?
Yes.
My lord, after this GA1 was heard and that order, my lord, was obtained.
My lord, to show that there is urgency and GA1 has to be heard and disposed of before 2nd August.
When did I say that? I'm saying my GA1 is infructuous tomorrow and I would have got a judgment by today, and by pernicious practice in contempt of court, all of you have colluded in undermining the majesty of this court and in obtaining release of a matter from a judge about to deliver judgment.
Okay.
Now, my lord, may I start?
So after this 16 July, this order was passed.
Yes.
Division bench has already fixed the
Yes,
date
and then
2nd July.
what remains right now?
2nd
Yes.
July.
And then the matter was heard.
Once the division bench has fixed a date for special and you have not challenged that order. So how this court can now restrain for second? I'm
not asking for that.
So what is the urgency? What is the urgency now?
May I indicate? My lord, they will keep saying, my lord, they'll keep saying that there is no urgency. GA number 1 need not be heard.
What is the GA? What is the GA1 number?
GA1 is what your lordship considered.
So that is to be heard on merit.
That is to be heard on merit. After affidavits completed.
Correct.
Your lordship released. We took it up, my lord. mentioned the matter and started hearing. Now affidavits are there. Question is whether the suspension was correct or not.
Correct.
Principle of law your lordship is well aware of is that once, my lord, ad interim stage is over, when the interim stage comes, observations at ad interim stage are not binding. So, my lord, I am entitled to a final hearing. In this order of the division bench, ad interim stage matters stood concluded. It is no longer possible to ask for an ad interim order.
Correct.
But
No problem.
the learned division bench, my lord, also said that at the interim stage, the matter should be heard. So, my lord, I had 8 or 9 days before the special board meeting, or more than that, 10 days, I requested for a hearing. 2 weeks, requested for a hearing. I got a hearing because after all, GA1 and the suit would largely be infructuous. Once, my lord, the special board proceeds on and my lord holds its meeting tomorrow. I had 2 weeks. I requested court. Court agreed. Your lordship agreed to release. Justice Mukherjee agreed to take up the matter. Matter was heard on the dates recorded in Justice Mukherjee's order. Hearing was almost concluded. That is when defendant number 5, who is not here today, who's only brought in, my lord, specially for certain purposes, comes forward and gets it released. After, my lord, the other defendants complete their submissions.
Okay.
So now, my lord, the situation is this. If your lordship
So now,
says, do I have
Why
jurisdiction?
you have prayed before the honorable single judge for constitution of the special board, and that was affirmed by the division bench. That was affirmed.
Was it my prayer?
Hmm.
Take the division bench order.
Yes.
What had happened was,
When they filed another application before the learned single judge, GA3 of 2025, praying for the following order: a direction upon the respondent number 1 to constitute a special board afresh and initiate a meeting to prescribe under 22G. What was the
because
purpose
we
of
didn't get any time at that point of time, my lord. There are two challenges. Number one is my challenge to, my lord, suspension.
Suspension is okay. I
Second is,
appreciate now that has to be heard on merit because the
yes,
interim order now
if I
affidavit is
succeed,
completed.
yes.
Affidavit is completed. Now it has to be heard on merit after exchange of affidavit.
Now,
what has been done before the court, I don't want to be a party on that. This court doesn't want to be a party on that.
No, my lord. It's not a question of, my lord, lordship, my lord, choosing to me. Luckily, I was not in court that day. If I was in court, I am sure, my lord, I would have said things which I would regret later. So I'm lucky, my lord, that I was in NCLT whole of, my lord, Wednesday when this game was played. I am very happy that I wasn't there. Mr. Ratnanko Banerjee was there. He was requested to come, and, my lord, he bore the brunt of it. Now that's, my lord, my lord, let's forget about that. Today we are in a situation where first is, am I entitled to an ad interim order to stop, my lord, special board meeting? Answer is no, after the division bench has said so. Second is, am I entitled to hearing of GA1? And if I succeed in that hearing,
the whole proceeding will
whole
go.
proceeding will go.
Correct.
Answer is yes, because the division bench has directed so.
Correct. See.
Now, my lord, may I put question 3? What remains in practical terms? Will it not be very difficult for me? Will it not create large number of complications if the special board meets and the whole thing is over? Why did I consent to it? Lord, would your lordship, question today is how much, Lord, your lordships will tolerate? How much will your lordships tolerate? At the end of the day, litigants come for justice. How much pernicious conduct will your lordships tolerate? And how much do we have to see happening in this court? My lord, our predecessors, my lord, have not had this misfortune. How much more do we have to see?
Okay.
My lord, I am humbly submitting this. Please, my lord, allow me. Today is a Friday. Tomorrow is special board. I had a final hearing. from an unbiased, fair judge of this honorable court, whom we have all known for a long time. We have done hundreds of matters before his lordship. His lordship had almost concluded hearing. Please give me 1 hour's time on the affidavits. I will, my lord, complete my submissions and let them, my lord, tomorrow's a working day. My lord, please hear the matter finally, GA1, before it becomes largely infructuous, tomorrow being the special board meeting. Under normal circumstances, this sort of an indulgence I would not be entitled to. But having regard to this extreme pernicious conduct of these litigants,
Okay,
my lord, your lordships
this
may
court-
give me this special
This
privilege.
court is not having any objection. If both the parties
Yes.
are ready, come tomorrow.
Lord, I don't care whether they are ready or not.
Because the-
Lord, I will start instead of wasting time on prejudice.
ये दे लो।
My lord, your lordship, my lord, dealt with it at the ad interim stage.
ठीक है, रहने दो, ले। No, then you come.
Lord, I am ashamed at what has happened in this court.
Come tomorrow. Come tomorrow.
No, my lord, please.
Not only 3:30 today.
Lord, please, Lord, 3:30, I am ready to violate and continue. 3:30 is not a I request your lordship. My lord, I would not have done this. But, my lord, I don't, my lord, somewhere deep inside me, my lord, I am told by my soul that do not allow these sort of people to win with this sort of conduct in this court.
Please, Mr. Chaudhary.
You should be.
See,
You should be.
See, what has happened, that is not before this court.
You should be.
So this court is not in a position to take all this.
Lord, give me 45 minutes. Lord, I complete hearing.
Has he given notice to all the parties?
Listed.
They were let him say so.
Nobody had notice.
Today has been assigned that it is mentioned. Just find out. He must have given.
No.
I take it.
Not to us also.
Nobody had notice. Milord, your lordship remembers at the ad interim stage.
Mitra, tomorrow is your meeting is there. Whatever the division bench is ordered there. If both parties come tomorrow, I will take at 10:30. Let it be finish it up tomorrow itself.
Yes. Milord, just give me 45 minutes.
Well, there are several. I am hoping for one debate. There are several.
Milord, till now, Mr. Mitro is the only advocate who's argued.
Yes.
Apart from release specialists that you've brought in.
Pernicious conduct.
Milord, defendant number 5 has not brought.
That's why since beginning this court is telling that this court is not going into the controversy. Only I find at 12:45 the file has come from the Chief Justice with the specific direction to list and hear the matter at 2. That's why immediately I directed my officer to list. I don't know what the procedure has been adopted by the office.
Yes.
Because this court cannot issue the note.
Yes.
They have to give notice to everyone.
If I had noticed, I came running.
If you persons have any problem, because today also 3:30.
Milord, please give me 45 minutes. I'll complete today. Milord, I am arguing today. 45 minutes. Give me, Milord, today. I'll complete. Affidavit now.
But I will point out, if they don't give notice to others, there will be somebody coming up.
There's a cause list.
This argument going on.
Milord, let us see whose wakalatnama kote thake. Milord, may I see, Milord, whose wakalatnama is there?
5 and 7, 11.
We have found out the release specialists, they don't even have wakalatnama, I am told. Please.
Previously, Anirban Ray appeared. Lordship may recall. Sunil Mehta appeared. Mr. Oindamitra appeared. I appeared. The 4 different party lordship had heard.
Milord, this is
The last order, 1 to 4. For 1 to 4 as per the last
order.
Mr. Mitro, Mr. Ray, Mr. Mehto.
Anurag Bagaria.
For 13.
For 13.
Anurag Bagaria for 13.
No, 5 has not appeared.
No, 5 not appeared.
Milord, we also don't have notice. 5 is the one who obtained release.
So who is Mr. Mitra is for the 2 and 3?
Yes.
1 to 4.
1 to 4.
As per the last order.
As per the last.
Now 1 to 4.
Achha, in that case. So Mr. Mitra, you are appearing for whom?
2 and 3 I'm appearing.
2 and 3.
Why you were appearing for 1 to 4 till yesterday? Why now 2 and 3?
Who is for the 1?
Why?
This is senior Mr. Mitra.
Why, he must be having an advocate on record.
Okay, okay.
Miller, please see this order. Mr. Mitra, Mr. Mukherjee, such and such, for respondent numbers 1 to 4. See the order. Please see. What is going on? Then, no. Then Bishwarup, then Bishwarup Bhattacharya. No, 1 minute. And Bikash Shaw for respondent number 5. वो गलत नामा है? Bikash Shaw? No. No, there is nothing. Then Mr. Aniruddha Chatterjee and Mr. Pranav Sharma.
Mr. Chaudhary, you do one thing. You issue the notice immediately. Come tomorrow at 11, 10.
They will never allow the matter to be finished.
Come tomorrow. Come tomorrow.
Millard, I'll give notice now. Hear me, Millard, for 15 minutes. Yeah, I'll give notice while this is going on. Millard, this is nobody else has made submissions. Before appeal court, nobody but Mr. Mitra made submissions. And they, before the learned judge.
And Mr. Mitra, if tomorrow if the meeting is taken place, whether tomorrow only the decision will be taken.
That I cannot say because this is
No, he can't say anything in this matter.
You may recall, the division bench order said that the division
I acted notice down a Pranav ke.
Because suspension could be considered by one is in court, other is by the special board. Now they agree the special board will so now and the division bench judgment from my lord judgment specifically holds that the special board proceedings the first judgment cannot be interfered with. The decision is taken thereafter. Rarest of rare cases, the court may interfere with the decision.
Millard, let's not, Millard. Why is he arguing on merits now?
Of course.
No, I asked him.
So, my lordship, as per the division bench judgment, first one, even second one, that only the decision can be challenged. I can handle. And my lord, kindly show paragraph 24 because they place them. Show the copy मिल गया copy तो set it there give to the full set give the full set
whatever whoever has filed
kindly takes a look at the
Anurag Bagaria dao
submission. This is all this is being done in contempt of division bench judgment. Now she kindly comes to the judgment.
Matter is being
the division bench judgment.
This is the case status.
Paragraph.
The two wakalatnamas, one before your lordship, the other is Anurag Bagaria, for whom Mr.
Summons been served. There is a question of entering appearance.
How much? Millard, I think Millard, one should stop somewhere.
Has to be served. Okay, you can't exclude.
Stop somewhere, Mr. Mitra. Stop somewhere.
Lordship, kindly sees paragraph 19 of this judgment. And this is whatever the prayer is in contempt of division bench.
Very good.
File a contempt.
File a contempt.
Paragraph 19, page 11. What audacity? File a contempt.
Yes, you file a contempt.
That was your order.
Yes.
Page 11, paragraph 19.
Yes.
We are prima facie of the view that there was no good reason or justification for the plaintiff to circulate the concerned message amongst the members of the club on 23rd September. The plaintiff had already written a letter dated 20th September.
Lord, are we doing a division? Is an ad interim order binding on the
there's no question.
Court in final hearing?
By conduct. By
so I will not be hurt.
If tomorrow if you take the special board meeting,
whatever decision they'll take, we shall be communicating to them. That's beyond me. Because all the past presidents, past presidents, what decision? And that the special board shall conduct the proceeding on 2nd August, strictly in accordance with rules and bylaws.
Millard, please read paragraph 32 of the same order which Mr. Mitro never places,
So far
it
as I am
says
concerned,
we clarify that all observations in this order are prima facie and have been made only for the purpose of disposing of this appeal.
The July judge, after that has come
Paragraph
Lordship,
32.
Lordship, tomorrow 10:30 I can be here. I will.
But today,
What,
3 o'clock, I am here. I want to argue, my lord.
I have no difficulty.
My lord, I am not
tomorrow.
concerned with
I
Mr.
can't-
Mitro's difficulties. I am concerned with, my lord, moving this matter. If he can come tomorrow, let him come tomorrow. Give me, my lord, this 45
Tomorrow,
minutes.
10:30
I will
can come.
complete. Because I can, my lord, bet my bottom dollar. Once he starts arguing, after he will not complete and he will try and push it beyond a point and say that by then it's been infructuous because special board has passed. And his client's pernicious conduct will support my submission.
The pernicious conduct
Yes,
has been
pernicious conduct.
accepted by my lord.
No.
By division bench twice.
We will
So
see.
so do not use those languages.
No, I will.
Tried twice and lost.
I will. I have not tried to get matters released from judges who are against me.
Paragraph 24.
I have not tried and I will never try.
Page 17, paragraph 24 of this judgment. Page 17. Paragraph 24.
Sir, may I
the
start?
Rules of a social club constitute
No,
a
no,
contract
please read
between
paragraph 32. It says it's all prima facie
That
for
was the
this
first
appeal.
order.
Then what is the point? Why is he reading this again and again?
Second order.
Millard, please take the petition. Millard, let me start.
No, Mr. Chaudhary.
Yes.
Let you issue the notice. Come tomorrow at 11:30. All parties may be directed, and whoever appear, I will take the matter tomorrow itself.
Millard, the only difficulty is, Millard, I'm very grateful, Millard, for this opportunity. But I'll come tomorrow. I'm glad for the chance. Only thing is, Millard, there is limited time because they will not allow, Millard, the matter to be concluded and they'll render it infructuous by, Millard.
For 2nd August meeting then.
Millard,
Why do you
I
agree?
don't want to get into this with Mr. Mitro. I have a lot. Millard, I'm finding it very embarrassing. Let's not, Millard, push this beyond a point. Now, if Millard, Mr. Anurag Bagadia is the only other advocate who has given notice, Millard, today. Millard Vakalatnama in the suit. I will take your lordship's leave for 1 minute while Mr. Sharka reads the order. I will call him personally and inform him. And I'm sure, Millard, that much of goodwill I have, he will come. Nobody else, Millard, has filed Vakalatnama. Nobody has a right of appearance. These, Millard, the special task release force, Millard, will come tomorrow. They will not come today. And in any case, I am under no obligation to give them notice because, Millard, they have not given a Vakalatnama. So, Millard, if Millard, your lordship has a heavy lift, your lordship has other matters. But, Millard, if your lordship gives us the chance, then, Millard, what I can do is I can tell Mr. Bagadia and continue. Otherwise, Millard, I'll come tomorrow. But, Millard, I'm telling your lordship, there will be, Millard, 5 other, Millard, gimmicks to ensure that the matter is not completed and the order comes. And he's expelled. The most unfortunate. Millard, we can do many things, Millard, but we stop before playing with the court.
When the matter was released on 30th, why you are not get it assigned early?
The order came at 30th evening.
Millard, 30th evening order came. We went to the Chief Justice and applied for assignment and with a copy of the order. And in all assignment matters, Millard, it takes a little time.
Court could have been passed an order, but binding upon the division bench.
I understand, which is why if I take, Millard, 45, 330 is not, Millard, binding on me. I have, Millard, up to 430. And I have, Millard, a little bit of goodwill to request your lordship for maybe 10 more minutes. So, Millard, I get my time, I summarize my arguments, place it. Then, Millard, if they don't come, or, Millard, if they come tomorrow and protract, your lordship can deal with, Millard, difficult people. Your lordship can, I am certain your lordship can deal with, Millard, this. I'm not giving it further adjectives.
Their conduct has been shown.
No, only the problem is that all the parties are not before this court. I mean, in the
All the
absence of
well,
one
that's
party,
the difficult. We will tell Anurag Bagadia right now.
that's correct.
We are getting him. Go जातो Anurag के थोड़े नहीं है. We'll get him.
That's
We'll
correct,
get
because
him.
the other parties are not there in their absence. If the court is taken, it is
There's just one
or again
party.
there will be a blame on the part. What is
No, there is just one. Yes, this client can go to any extent.
I am not telling that. So that's why all the parties should present, and there will be no difficulty for this court to take even after 6:30 also. There will be no.
Yes, I know that.
There is no difficulty. But the problem is that all the parties should be represented.
I will not leave it to your lordship.
If all the parties are represented, this court has no difficulty. I will
Milord,
release other
now,
matters.
yes, how do we decide, Milord, who's to be given notice?
Only on
Milord,
Who has appeared? The last order who has appeared.
last order, Milord.
Last order, you are for the plaintiff.
Yes.
Mr. Mitra is already there 124.
Yes.
Correct. And Mr. Biswarup Bhattacharya for the respondent number 5 and respondent number 11. Let this two persons be given notice.
I'll inform them.
Let they come.
Mr. Bagadia is coming. Only other person who has Vakalatnama.
Because so.
They have not filed wakalat.
They have not filed.
But you are allowed. Now today you cannot.
No, what can you do? Milord, today, Milord, think of it. Both of us are arguing. If Milord, Mr. Shorka suddenly comes and says, I am for defend number 5, you are biased. Release my matter. What will your lordship do? Record his name and release the matter. What else will your lordship do? Will your lordship, Milord, get into this skirmish? What will your lordship do?
Okay. You see whether notice is served. I will take at 3:50.
Yes, Milord.
If notice is served, then we'll see.
We'll just give notice and proceed.
Let him make his submission. My papers are not
Okay. No, I am not taking. Let 15 whether notice is served.
Yes. Notice the email for
email. अभी email. हाँ विकास हाँ दोनों को कर.
Yes, call. Yes.
So there were certain directions given by your lordship, and I have to give certain documents which I'm handing over where it is affidavit. I didn't see your lordship's draft order.
May I have a lot kindly? This is that matter.
Yes, report has come.
I do not know, my lord. Lordship's in his kind wisdom, my lord, has already directed.
General manager, postmaster.
This is the affidavit of service. We call several service, my lord.
Who is Mr. Arnava Ganguly? Today is present.
Arunava Ganguly.
My lord, he on the other day appeared for, my lord, the BSNL, I believe. So far the bank are concerned and the other, my lord, the government institutions, though notice has been caused, my lord, but nobody, my lord, appears
Your
to.
lordship has made it clear that if on the date fixed, if the authority of the respondent fail to submit the report in terms of the order 15, appropriate orders will be passed. None of them are coming.
My lord, your lordship has also made a clear, my lord, on the very first, the other judgment that there has been anomalies by his client.
Don't say all this.
No, that is on the paper, my lord.
Item delivered.
Last order stands.
Item delivered.
This is order is subsequent to that order.
Nobody is appeared. Yes, it is from the office. It is delivered to all. Nobody is. So I am issuing the warrant against all of you, all of them.
My lord.
What can be done?
And my lord, if I say that concerned police station along with the SP of should be directed, my lord. And my lord is may also be pleased to see, my lord, that this was your lordship's, my lord, original order. Kindly have a look to, my lord, order of 15th January.
Yes. Yes.
Kindly see, my lord, paragraph 42. At page 22.
Yes. Respondent number 1 has also.
Yes,
not.
my friend's client, my lord.
Yes. Where is your
The great lady, my lord, who.
where is your report?
And
File report.
Yes, yes.
Fine.
report.
The
I do.
affidavit.
Affidavit.
And my lord, kindly also see paragraph 43, the very next page. Very next page. Lordship has made very clear that at this stage, the court is not inclined to remove the one from administrating, but for the benefit, it would all proper for to first ascertain the actual rents collected by the respondent number 1. And that is why, my lord, these directions are given. So 42 followed by 43 and, my lord, 44.
Okay, yes, file the affidavit. Yes, file the affidavit. Serve the copy. Serve the copy. Learned counsel appearing for the respondent number 1 has filed the affidavit in terms of the order passed by this court dated 15th of January 2025 after serving the copy to the learned counsel for the petitioner applicant. The applicant is liberty to take exception, if any, within a period of 2 weeks from date.
Lordship.
Take exception, if any, of this report.
My lord, this is a report one after another.
The affidavit. That's why if you take, then there is no further. Then the
And I believe, my lord, if your lordship, my lord, kindly allow me to take to paragraph 42 once again. My lord,
Okay,
there has
you go through it. If it is not compliance with these 2 paragraphs, then you come with the return.
my lord,
We will take.
my lord, may I say this? Here, my lord, there has been no direction to the respondent number 1 to file any affidavit further. Lordship has taken all the affidavits.
No, with regard to this, this court wants, he has given the report on.
No, my lord, there was no such directions upon him, my lord.
Kindly see.
There was no such directions upon him. Kindly see, my lord, Lordship's own judgment at 15th January 2025. Lordship has considered all the purported reports, affidavit, whatever in whatever form. And, my lord, this order was passed, whereupon, my lord, your Lordship, kindly see para 40 onwards. At page 22.
Yes.
This is something a ploy, my lord. Please, Mr. Bose, please, Mr. Bose, please, Mr. Bose, my voice is more louder than you. Please keep silent. Now the question whether the respondent number 1 is liable to be removed from administering the property and credits of the deceased for not disclosing proper inventory. Lordship has found, my lord, paragraph.
And come to page 24 of the inner page 24 of
Lordship.
the order, clause E.
Lordship.
The respondent number 1 is.
Yes, this is only, my lord, the details of the rent collected.
That's why he has given the details.
That is why I have submitted.
He has given the details. You go through. If anything is there, you come with that. Then we. It's not that. Then
Please, Mr. Bose, control your.
Please, you also
do
don't
not, do
mislead
not,
the
do not.
court. Do not mislead the court.
Mr. Bose, please. Keep silent.
I know you are an insane person. I know you are an insane person.
Yes, I am. And you are a good communitarian.
What he is submitting?
Senior person.
What he is submitting?
It is not good.
But he submits that we are making some rubbish submissions.
Using this type of the word in the open court, it is not good. So, by within 2 weeks, full stop. By an order dated 15th of January 2025, this court directed Chief General Manager, BSNL, Postmaster General, branch manager or any of the competent authority of the Punjab National Bank, officer in charge of the Integrated Child Development Services, Nandigram, executive engineer WBSEDCL, and the officer in charge of the Nandigram police station to submit report. In spite of the specific direction passed by this court dated 15th of January 2025, none of the authorities have filed their report. Full stop. Subsequently, by an order dated 13th of March 2023, again, this court has given an opportunity to the said authorities to file report. In the said report, in the said order, it was also made clear that by the date fixed, if the authorities and the respondent authorities fail to submit the report in terms of the order dated 15 January 2025, appropriate order will be passed. In compliance of the order dated 13 March 2025, the Office of the Registrar, origin side of this court, has forwarded the order to all the authorities by speed post, and the set has been duly delivered to all the authorities. The registrar origin side has submitted the report. Let the same be kept with the record. In spite of receipt of the orders, till date the authorities have not filed any report before this court. Considering the above, this court finds that the authorities mentioned above are willfully and deliberately violated the order passed by this court by not submitting the report dated in compliance of the order dated 15 January 2025. Considering the above, full stop. Let warrant be issued against.
My lord, may I just indicate the SP is maybe directed to execute because here Nandigram OC is also an accused.
Warrant be issued against Chief General Manager, Bharat Sanchar Nigam Limited, Postmaster General, Post Office, Branch Manager of the Punjab National Bank at Nandigram, Officer in charge of Nandigram Police Station, through the concerned SP of the Nandigram district. It's a district. Nandigram is the village.
Midnapur. It's in East Midnapur.
The East Midnapur district of the East Midnapur district. Full stop. The SP district is directed to submit the report before this court within 2 weeks. Full stop. The applicant is directed to take appropriate steps for filing requisites for issuance of warrant against the said person, against the said officers by Tuesday.
Well, the Registrar General may be directed.
They will do, but you have to give the requisites. By Tuesday?
No.
You have to give the requisite, then the rest. Full stop.
By Wednesday.
By Wednesday. By 6th of August 2025. The Registrar General, on the Registrar original side of this court is directed to issue the warrant through the SP East Midnapur district for execution and report. Let the report be filed on 22nd of August 2025. Release the matter on 22nd August. Next.
The very hot atmosphere in court today. Normally,
take steps immediately.
Normally, Friday the atmosphere is not like this.
Lordship has kept on 21st. 22nd.
Friday.
And my lord, one sentence if may be added, my lord. On 21st, SP may be directed to execute the.
Direct.
Lordship has said that up to file a report.
No, execute and
file it. I'm grateful. Extremely obliged.
बुला उसको
এটা দেখি দেখলাম তুই এটাই দিলি আমাকে Well, this is an originating summon suit.
Yes.
Temperatures are pretty high. So I will try to bring it down to normal.
I have to keep cool.
Yes, but I have 5 minutes.
Nah, I have to keep cool.
Exactly. On a Friday, my lord. My lord, kindly, my lord, come to, my lord, here, what is kindly, my lord, this is related to that Vadhva matter your lordship is Your Lordship remembers when Mr. Ray was appearing and I was led by Mr. Shuman Dotto.
Yes.
My lord, we have sought for, my lord, recalling of the letters of administration, your lordship, and that is pending. But what has happened is, this, my lord, person who has taken the letters of administration, you know, Anushwa Pujara, her son, Anushwa Pujara is no more. She is dead, my lord. Her son has, my lord, appointed himself, my lord, directors in 2 companies. And my lord, the family, the Wadhwa family has 4 trusts. Now these trusts, my lord, the trust deeds say that only, my lord, living persons can be trustees. Your lordship knows generally, because the position of trust is that of, my lord, fiduciary capacity, my lord, discretion of the trustees, my lord, a personal element is involved. My lord, divorce that clause of the trust, they have got, my lord, these companies where companies appointed as trustees. And religious trust, my lord, to upkeep of the Thakurs. I will place those clauses. Clearly, the clauses for appointments are mentioned that the person will be appointed. The eldest male member of a particular branch will be appointed. They have given a go-by to that. They have appointed companies, and he has himself appointed himself as a director of these companies. And my lord, frittering away the entire assets that has come to these, my lord, trusts by way of this grant of administration. My lord, I have, my lord, kindly, my lord, first, my lord, take that, my lord, one of the trust deeds. Page 15, one of the trust deeds start.
Who is the defendant? He should notice. He should notice.
But I will. But if the entire properties go out by that time by these companies as trustees, my lord, nothing will remain. Already, my lord, I am told, my lord, after the, my lord, that hearing is going on, they are, my lord, also already doing it. Kindly see one clause whether this can allow them.
What has happened? That hearing is still going on.
Is going on. My lord has fixed it.
It is fixed.
August. Well, it will take some time, but in the meantime, what they are doing, they've realized what is going to come. My lord, kindly protect me to that extent, and my lord, my lord remembers the pending the revocation, my lord, the will has surfaced. My lord knows, my lord. Kindly see, my lord, one, my lord, 2 clauses. 2 minutes I'll take, my lord. Kindly see 2 clauses of the, my lord, trust deed, which I am referring to. Your lordship will come to, my lord, page, my lord, 48.
Yes.
But kindly see, my lord, 1 and 2. Any of the trustees for the timing of the said trust estate will be entitled to retire from the office of the trustee.
48.
48, my lord.
Yes, any of the trustees.
Will retire from the month's notice in writing of his intention to do so, remaining trustee for the timing of the said trust. 2. Subject to what has been stated here, in case of any vacancy occurring in the office of the trusteeship by death, retirement without death has to be for a normal living person, without making any appointment in terms of these presence, or in case of any vacancy on account of removal of any trustees for the time being, on account of unfitness or incapacity, the surviving and continuing trustee or trustees for the timing, as the case may be, the said trust estate will be entitled to appoint a new trustee in place or stead of the trustee so dying, kindly see dying, or retiring without making an appointment of being removed. If, however, the sole trustee dies without making any appointment in terms of these presence, or becomes unfit or incapable of acting as, or is removed, then in that case his nearest male lineal descendant, or the nearest male lineal descendant, if there be more than one, and failing such lineal descendant or descendants, his nearest heir or the nearest heirs, if there be more than one, will become the trustee or trustees, as the case may be, of the said trustee estate. Clear, my lord, it has to be a living person. Now, my lord, what they do, they, my lord, appoint, my lord, kindly see the deed of appointment of, my lord, 2 companies. Page, my lord. My lord, kindly come to the appointment, page 51. Deed of appointment of trustee.
Yes.
Kindly, my lord, come to straight away page 52.
It is obviously with regard to the, kindly see with the page 51. Deed of appointment of trustee made on such and such is entered between Govardhan Das Jerambhai Wadhwa and Mr. such and such Wadhwa, Indian inhabitants. The trustees of the Kalishankar Radhesham having its office at such and Wadhwa Endowment Management Private Limited. Kindly see, a company incorporated under the Companies Act having its registered office at such and such, hereinafter referred to as W, and Jerambhai Management. These two companies.
Where from you reading?
But page 51.
51, yes.
Kindly see WEMPL.
Govardhan Jalman.
Yes. Just after that, my lord. A company incorporated under, first is, my lord,
Management Private Limited.
Wadhwa Endowment Management Private Limited.
And Jembavani.
Referred to as WEMPL, and, my lord, Jerambhai Management Services Private Limited, JMPSPL. As together referred to as new trustees. Lordship has found. So, my lord, these two management companies are being appointed as trustees by dint of that clause in the, my lord, trust deed, which says only lenient eldest male members. That is, my lord, a living person. Now, my lord, they are frittering away this, my lord, entire, my lord, assets that has come to these trusts, or rather parked in these trusts, by way of this dint of letters of administration. Until, my lord, the lordship is hearing the, my lord, recalling, my lord, the entire property will be taken out from this trust by dint of these companies, which have no right to be trustees in these trusts. But I am only to the, I will serve, but I am only, my lord, kindly come to the questions frame. I know there is paucity of time, and Mr. Chaudhary is cursing me from behind. But, my lord, kindly, my lord, come to page 8. My lord, kindly see the questions frame. And, my lord, kindly see, my lord, all I am framing is F at page 10. Whether an order to restrain the said company from transferring and alienating and dealing with or selling and encumbering or parting with any of its assets, jewelries or money kept in savings bank account and fixed deposits. And, my lord, only this, that the company should not transfer further assets of these trusts. Now, my lord, question is there, my lord, as to whether judgment whether this sort of an order can be passed. Your lordship's own, my lord, judgment, my lord, kindly considers in a, my lord, originating summons suit, your lordship has protected at the ad interim stage. There are judgments of division bench also, my lord, kindly, my lord, come to same questions raised regarding, my lord, construction and management of a trust deed. My lord, finally, my lord, your lordship has, my lord, protected us, my lord, page 5. Accordingly, defendant is restrained from operating the bank account maintained in the name of the trust with the State Bank of India in Tally branch till 3rd October. This was also similar facts, my lord, glaring. Here, of course, facts were different, but question is, my lord, it can be done. My lord, that there's another division bench I'm citing, my lord, 19, my lord, 88 to CHL, page 78. Here, my lord, even, my lord, in a bank guarantee matter, my lord, the learned trial judge had, my lord, passed an, and in an originating summons suit on a bank guarantee, learned trial judge had passed an order of injunction. Kindly takes, my lord, paragraph 4. In the matter under consideration, it appears that the plaintiff respondent has applied before this court under chapter 13 of the rules of original side of the court by way of an originating summons and obtained an ex parte order of injunction restraining the enforcement of bank guarantee by way of an ad interim interlocutory relief. And then, my lord, goes, my lord, on different points, my lord, whether what should be done. But, my lord, this is not, my lord, inconsistent with the rules or, my lord, the practice of the court that just because it's an originating summons, no interim relief can be granted. Because ultimately, if your lordship has to decide the matter, the subject matter of the dispute before your lordship, whether it be normal suit or originating summons suit, my lord, has to be preserved. All I'm saying is, if time...
Who are you?
I am, my lord, that person who has, my lord, sought for recalling of the grant. And, my lord, if the grant is recalled, I'll be the person. Eldest member of the Wadhwa family. Jai Shri Wadhwa. And, my lord, somebody is control is Nirmal Pujara, who is outside, my lord, of these companies. Kindly see page 56. Pinky Nirmal Pujara. Daughter, all outsiders are controlling this company, and this company does not have a right to be a trustee in these trusts, and they are, my lord, frittering away.
Who is the Lalanji Jha?
They are all, my lord, peons, if I may say so. They are all outsiders, nobody from the Wadhwa family. And, my lord, if the grant is, my lord, recalled today, I'll be the member the person who would succeed. Your Lordship knows we are making, my lord. Limited prayer, let these companies do not, my lord, transfer any further properties as trustees. My lord, this is not going to affect them. If after hearing them, my lord is, my lord, minded to, my lord, recall the order, your Lordship will do that. But today, my lord, in 5 days or 7 days, if they do not transfer any assets, my lord, no prejudice can be caused to them. The trust. And my lord, trust, what is the object? Object is Shiva Puja. It is not a banking company or a business company which is, my lord, doing, my lord, business on a day-to-day basis. Only limited to this, I am saying.
The plaintiff has filed the present originating summons suit, praying for, seeking an answer to, seeking an answer to the opinion, seeking an opinion from this court as appearing in paragraph 16 of the present suit, out of which one of the opinion, whether, inward comment, whether an order to restrain the said companies from transferring and oblique or alienating and oblique or dealing with and oblique or selling and oblique or encumbering and oblique or parting with any of its assets, jewelries and or money kept in the saving bank account and fixed deposits till the disposal of the instant originating summons suit can be passed. Fully. Mr. Rupak Ghosh, learned advocate appearing for the applicant, plaintiff submits that the petitioner, the plaintiff is the widow of one Dilip Wadhwa, the widow of one Dilip Wadhwa, who was the son of one of the brothers of Damodar Das Jerambai, Jerambhai Wadhwa, who died on 29th of July 2022. Full stop. The plaintiff has already filed an application being GA1 of 2024 in PLA number 471 of 2022, praying for revoking of the grant passed by this court in respect of the will dated 11th February 2020. And the said application is pending for adjudication. Full stop. Counsel for the Mr. Ghosh submits that recently in the month of April 2024, the plaintiff came to know that Anusuya Pujara, being a sister of Damodar Das J. Wadhwa, counsel for the Mr. Ghosh submits that during the inquiry with regard to the estate of Damodar Das J. Wadhwa, the plaintiff came to know that Mr. Ghosh submits that the majority shareholdings of the Wadhwa Endowment Management Private Limited and Jerambhai Management Services Private Limited was held by Damodar Das Wadhwa, holding 98.975% shareholding. Full stop. The Damodar Das Wadhwa was also one of the directors out of the two companies. After the death of Damodar Das Wadhwa and grant of letters of administration in favor of Ansuya Pujara, shareholding has been transferred in the name of Ansuya Pujara. After the death of Damodar Das Vadua, son of Ansuya Pujara, being namely Nirmal Pujara, was appointed one of the directors of the said companies. And after grant of letters of administration in favor of Ansuya Pujara, wife of Nirmal Pujara, being the Pinky Nirmal Pujara, has been appointed as director of the said companies. Good stuff. Counsel for the Mr. Ghosh submits that now the plaintiff came to know that a deed of appointment has been made on 14th of December 2010, wherein two of the companies have been made as trustees of Damodar Das
As different number one trust.
as trustees as the trustees of the defendant number one trust. Police counsel for Mr. Ghosh submit that the company cannot be made as a trustees of the trust. He has relied upon the judgment in the case of State Bank of India versus Mohura Gang reported in 1988 SCC Online, Calcutta 124, wherein the Honorable Single Bench has granted the interim order in the originating summons suit, which was duly confirmed by the Honorable Division Bench. Mr. Ghosh has also relied upon unreported judgment passed by this court in the case of Shekhar Goa and others versus Shamli Basu, wherein in the said case also this court has passed an interim order restraining the defendants for operating the account of the trust. Considering the submission made by the counsel for the plaintiff, peruse the materials on record and the judgment relied by the defendant. This court relied by the plaintiff. This court find that two of the companies have been made as trustees of the defendant number one trust. The plaintiff apprehends that the said companies will alienate the property, and an application is pending for revocation of the will. In the present suit, also the plaintiff has prayed for an opinion, asked for an opinion from this court. Considering the above, this court find that the plaintiff has made out a FSA case and balance of convenience and inconvenience in favor of the plaintiff. Accordingly, the defendants are restrained.
Then be ready for a profession. Everyone is not as brilliant as Rupak.
Defendants are restrained from transferring, alienating, dealing, selling, encumbering, or parting with any of the assets, including the bank, including amounts and the including the amounts lying in the bank account and the fixed deposit till 22nd of August 2025. The plaintiff is directed to issue notice upon the defendants immediately and to file affidavit service on the returnability. Yes. Now, yeah.
Yes, may it please your lordship note. Yes. I appear on behalf of the contempt numbers 1 to 6. The earlier advocate on record is still there. He is not. The ladies and gentlemen have appeared, my lord, in terms of your lordship's direction. There was a huge communication gap somewhere. Kindly permit us to explain our conduct, my lord. It is as I find from the record today, without further explanation, I find that the conduct is not above board. Kindly permit me to explain it by way of affidavit. It's only after I satisfy your lordship that it is worthy of an explanation that my lord will permit me to address your lordship.
My lord, I appear on behalf of alleged contempt number 13.
Where is the contempt application? Who are,
Lord, I am for the petitioner.
who are present?
Lord,
What team is
Rizwan, Imran, Arif,
Yes.
Arif, Tariq, Siddiq, Malika Khatun. So six persons are present.
1 to
6 persons.
yes, ma'am.
Yes.
1 to 6 as well.
What is the order? Where is the order?
And my lord, 13 is also present. Ma'am.
My lord, number 7 is also present.
Rajni Devi. Rajni Devi. Who is there? And Rizwana Khatun. 8 is not present. Warrant is against all.
No, my lord, kindly takes your lordship's order of 18 July. Warrant is against 7 to 13, and my lord, 1 to 6 were only asked to be personally present. There's no warrant against
They are
them.
personally
They
present.
are personally present. What Mr.
1 to 6 to file their affidavit of complaints when the matter is filed today. No affidavit is filed. Accordingly, 1 to 6 are not interested to file their affidavit.
No.
Direct to appear before this court in person. And warrant against?
Warrant against 7 to 13.
7 to 13.
Second paragraph.
7 is Rajni Devi.
Yes.
Present. Rizwana Khatun. Who has arrested? Who has brought on arrest?
This officer was there, my lord. Shamne Ashok.
Who has brought on arrest?
4 of them are here.
Huh?
4 of them.
Where is the Sarif? Where is the office of
Charge on arrest. Police officer.
बेलीफ ऑफिसर कोई आया नहीं कौन है
Come forward.
ऑफिसर के आस्ते बोलून सामने
Who is from the bailiff office? What are the names?
Rijuana Khatun, wife of Mohammad Alauddin. Sama Khatun, wife of Awes Mohammad Tariq, 10 number. And 11, Rijuana Khatun, wife of Mohammad Amjad.
4 persons.
4 persons.
Where is the police personnel? What about the other? 7 and 12? 13 is sub-register.
13 is the
7 minor.
one at a time, please.
I am on behalf of number 7, Rajni Devi.
So she is not brought under arrest.
No. So Lordship, I am on behalf of respondent number 12. She is now unable to come to this state because she is having some gynecological alignment. For that reason, she is under medical treatment.
Who is the police officer? You. Rajni is present. Why you are not arrested? रजनी का वारंट है
जी
तो अरेस्ट क्यों नहीं किया आपने
कोर्ट में नहीं जाना
हाँ
कोर्ट में प्रेजेंट हुई थी
कोर्ट में प्रेजेंट है तो आप अरेस्ट नहीं करेंगे आपके पास वारंट पेंडिंग है तो
यस सर
तो जब आपके पास वारंट पेंडिंग है तो आपने उसको देखा तो अरेस्ट क्यों नहीं किया आपने
कोर्ट में नहीं किया
हाँ
कोर्ट में मना किया था अरेस्ट करने
कोर्ट ने मना किया
कोर्ट में प्रेजेंट रहने पर अरेस्ट करने से मना किया था
कौन
सुप्रीम सीनियर ऑफिसर मना करते हैं कोर्ट में खुद सरेंडर होता है मत करिए
सरेंडर कहाँ है और रूबी परवीन कहाँ है
नहीं है
रूबी परवीन अरेस्ट नहीं हुई है
नहीं
मिली नहीं है आपको
नहीं
यस what is the order
Order is 18th of July 2025, your lordship's order.
Page?
No, but your lordship is on the original order of injunction which they violated.
Director submit their statement of account. Yes, why they are not complying with Mr.
The only as far as my clients are concerned, my lord, they have certain an explanation to furnish to court regarding the fact of payment of certain monies. They were, my lord, under a I am told under a misapprehension that they would be required to pay that money. Subsequently, they went and found that there was no requirement for them to pay that money because their case may not have been properly represented. These are loose instructions. My lord, kindly permit me to put something on oath to explain my conduct first. It's not been a good conduct. I'm not going to make any submissions today, my lord. It's not been a good conduct at all.
Today I will release them, whether you will be able to catch hold of them. I don't think so.
No, my lord, it will be very difficult, my lord, for me to catch hold of them, but I can only, my lord, as an officer of court, I can request your lordship to be slightly more lenient, my lord, so that they are available at your lordship's beck and call.
I don't think so.
My lord.
Several efforts have been made by this court, subsequently have been...
No, there was a gentleman involved here. That gentleman, my lord, there was some misunderstanding, miscommunication.
No. They are very influential person in the behalf.
Oh.
They have managed the total police up till the DG. There's a person, there is a report that this named persons are not in the village.
Oh, Lord, I've just
seen kindly see the act. One of the person is present, he is not arrested. And so stated the higher officer stated them not to arrest.
Oh, so these are not my clients, luckily. 1 to 6 are my clients, my lord. I have brought them. They were told to come personally, but I am not.
They are lucky. They are the he is in the Bihar police. Other he was in the West Bengal police.
Yes.
I could have been given the lesson.
Yes. Superior officers, he himself said. I mean, he said it in court.
As far as 1 to 6 are concerned, since Mr. Banerjee is here, let them file.
1 to 6 you are appearing?
Yes, I've been instructed to appear, my lord. I will file my affidavit explaining my conduct and explaining their stand. And thereafter, leave it to your lordship.
And what about the arrestees?
The arrestees, I'm not appearing.
My lord, so far as 13 is concerned, my lord, the registrar, he is personally present before your lordship.
13?
Yes, my lord. 13. Sub-registrar.
Because despite serving the order of injunction, he has allowed these deeds to be registered.
That definitely, my lord, will also come back. My lord will also come back, and your lordship will kindly grant us some time to, my lord, explain what has happened.
आप यहाँ आइए, please come here. आप तो एसडीएम है ना, एसडीओ है?
नो सर, सब रजिस्ट्रार।
सब रजिस्ट्रार है
सर।
सब आप एसडीएम का पोस्ट कभी होल्ड करे हैं?
नो सर,
नहीं करे हैं। एसडीएम का पोस्ट क्या होता है मालूम है आपको?
यस सर, लिटिल नॉलेज।
अगर एसडीएम आप एक ऑर्डर करते हैं
सर,
तो आप जो है जिसका अगेंस्ट में और वो ऑर्डर को कंप्लाई नहीं करता तो क्या करते हैं एसडीएम साहब?
सर
क्या करते हैं? छोड़ देते हैं, जाइए चाय पी के आइए।
नो सर।
फिर जब कोर्ट ने आपको एक ऑर्डर दिया, आपने कोर्ट का दिया, आप यू आर यूपीएससी
बीपीएससी
यूपीएससी elected, you know all these things, the procedure.
Sir, I'm a new official, sir.
New officer, you receive the summons.
Sir.
Why you're not appearing?
Sir,
there was definitely some miscommunications, my lord. Lordship, my lord, he is a responsible officer, and I'm taking, my lord, his responsibility, my lord.
No, that's why I called him in the dog.
Yes, my lord. For 13, my lord, I'm taking responsibility, my lord. Lordship will kindly, my lord, because he's a responsible officer. He's discharging his duties over there. There definitely has been, my lord, some elements which we need to bring it before your lordship, my lord.
That other part of my lord, I was not aware that all that has been.
And what about the arrestees? But the other arrestees?
I believe, my lord, 2 persons appearing through their learned advocates.
जो अरेस्ट हो गया, कोई वकील किए हैं? पूछिए कौन है वकील? ठीक है, आप उतर जाइए।
सर, थैंक यू
सर। असुविधा हो गया।
वकील नहीं किए?
Legal aid
they can be.
Now, that's if they ask for legal aid. If they don't ask for legal aid, they'll give it. No.
The court has to offer.
Offer.
Otherwise, I will be in contempt on a 21.
Lord, kindly record your undertaking that they will be present.
आप लोग क्या बोलना है? आप लोग क्या बोलना है?
हमको बोलना है मतलब उन्होंने बेचा तो हम लिए
हाँ
उन्होंने बेचा तो हम लिए खेत
आपने बेचा नहीं है
Because they have sold, we have purchased. They have sold, we have purchased.
C word. C word এর C পার্টটা ওয়ার্ড হচ্ছে
आप लोग वकील नहीं किए आप लोग को वारंट में लाया है मालूम है अभी anybody is from legal aid here any advocates who is appearing for the legal aid
Oh, he is very forthcoming in legal aid.
they are the persons brought under arrest
Lucky day for them.
lucky day for him also. He gets to
Hopefully everything simmers down now.
and
he is not only doing legal aid for
you are also from Yasin Banerjee
হ্যাঁ
He had cautions of it. And every day, it is such a nightmare. 9:30 in the morning, one phone call from Justice Banerjee. You have item numbers 4, 10, 15. I hope you have seen.
But Lordship has done the right thing. Even if they don't have, you know, that's loss.
Very sorry. I'll take it. এই তো ছিল না এই তো
সৌমাকে স্পেশাল কাউন্সিল করে কিছু বলছিস না
take care of it. The lady who's been arrested.
All ladies. 6, 7 ladies.
Yeah, higher purchase execution.
Injunction order তার ভায়োলেট করে ডিড করে নিয়ে প্রপার্টি কিনে নিয়েছে they are the purchasers
ও জানেই না কি করতে Blood, I will, my junior will take charge and we will do. Blood, Ms. Ujjaini Chatterjee.
মামলা করবে হয়ে গেল দুটো মামলা
আসবে আবার চেম্বারে খবর নেবে
No, my lord. A report was supposed to be filed and he was informed.
somebody appeared for us
হতে পারে
আমি দেখলাম
কেন হবে না যা তুই বল ওখানে and opinion and direction yes sir তুমি ওকালতনামা কার নামে করবে করে the state legal service will take pilot find out and do it state legal করতে হবে তোমার এসে ওকালতনামা
Seven.
একটু অ্যাপিয়ারেন্স গুলো নিয়ে নেবেন কিন্তু কে কারো অ্যাপিয়ার করছে কেউ কাউকে পাওয়া যাবে না Yes, my lord.
3 weeks করে না এদের না বাইরে নিয়ে গিয়ে বসে সব ঠিক তো সেটা জানি না কি ভালো করে বোঝো হ্যাঁ
We paid by mistake situation.
Thank you.
My lord, so far as contempt, alleged contempt number 13.
Lord, Lord, also
1 to 6.
Your Lordship is pleased to, my Lord, direct state legal services and say that, my Lord, I will, my Lord, represent. But I'll do the needful.
Very resourceful. 1 to 6, my lord, may I seek dispensation on the next day? They are appearing without a warrant.
Yes, no problem. Mr. Banerjee is appearing.
Thank you.
Obliged. Obliged. Greatly obliged, your lordship.
My lord, before rising, may I submit? My lord, I have expressed your lordship views in the morning, but the department refused to accept without specific endorsement of the grant leave for filing this application. For application for recalling of your lordship, modification of your lordship's order. Only for the word plaintiff instead of the caveatics. That I have shown in the morning, your lordship directed to submit before this court, before the at about 1 p.m. My lord, I have tendered to Mr. One Ivan, who refused to accept without specific.
Grateful, my Lord, if your Lordship, my Lord, takes a break and comes back, my Lord, we'll start off. From 4:30. Lord, Lord, I don't mind waiting, my Lord. Or if your Lordship wants tomorrow, my Lord.
The notice.
We should notice. Yes, 10:30 tomorrow I'll be here.
Done.